check. Hello. Hello, check, check. Hello, check. Check, hello.
Paging for everybody behind. Ladies and gentlemen, kindly occupy the front rows. We're just about to begin. Can we stop the music, please? Thank you. Thank you, Console. Ladies and gentlemen, good evening. We're just about to begin. Everybody sitting in the back rows in the middle, can you please stand up and occupy the first 3 rows, please? After the VIP chairs, kindly occupy the front rows. Thank you so much. What an amazing audience. Thank you so much. Ladies and gentlemen, thank you so much for being on time. We apologize for starting a little late. We're waiting for more people to come in. Can I hear a big round of applause for everybody present out here? Thank you so much. Good afternoon, ladies and gentlemen. Distinguished judicial luminaries, respected government officials, members of the legal fraternity, apartment owners, students, guests, and friends. A very warm welcome to Proprietas 2026. Ladies and gentlemen, a big round of applause for everybody present around here. Thank you so much, ladies and gentlemen. Allow me to introduce myself. My name is Shabbir, and it is my privilege to serve you as the Master of Ceremonies this very late afternoon. Today's event brings together eminent judges, policymakers, regulators, legal practitioners and subject matter experts to help us better understand the legal framework governing apartment ownership and property transactions in Karnataka. Over the next few hours, we'll explore not only the law as it exists today, but also the practical realities faced by apartment owners, housing associations, developers, lawyers, and public authorities. Ladies and gentlemen, we hope that every participant out here leaves with a greater clarity and awareness. On behalf of the organizers, a big thank you for being out here and contributing to this important awareness program. Ladies and gentlemen, I now request all the dignitaries present out here to please come up on stage to light the lamp. Can I hear a big round of applause for the dignitaries? Ladies and gentlemen, let's invoke wisdom, knowledge, and guidance to a traditional ceremonial beginning. Thank you very much for joining us, sir. What an honor. Ladies and gentlemen, the dignitaries on stage. Give them a big round of applause. Can you please join us for lighting of the lamp, sir? Please. Thank you. Please. It was really mellifluous.
At the outset, let me beg you of all of you for making the departure from the set protocol. Maybe there would be some more invocation songs and thereafter the traditional welcome speech, introducing the guest speech. But I'm sorry, I'm breaking from all these things because I have to catch a flight at 5:55. So it takes an hour and a half from here to reach the airport. So please pardon me. Professor Ramchandran, who has mentored thousands of students and who has been a district judge in Kerala, his erudite pupil, Madam Veena Pillai, who is also the ceaseless fighter of hundreds of causes, not one or two. She is a ceaseless fighter of hundreds of causes. When she used to appear before me, in some cases I always felt that she were my advocate. I may or may not have agreed with her, but I am very appreciative, you see, of her research, her investigation, and her, you see, commitment to espouse the cause of the client. And policymakers, bureaucrats, property developers, academicians, research scholars, students, and all other members of this very, very distinguished gathering. It gives me immense pleasure to be amidst you to share my random views on managing apartment communities with legal clarity. I will not take more than 8 minutes. When we purchase an agreement, we are not just buying a roof over our head. We are buying a promise. Promise of what? Promise of community living, promise of modern amenities, promise of shared security and hassle-free lifestyle. The very foundation of an apartment rests on the Residents' Welfare Association or Apartment Owners Association. Apartment living is a social contract. It's a promise that a community of strangers will share walls, waters, corridors, lifts in a spirit of mutual respect and legal accountability. The law is just an instrument that keeps this promise enforceable. You have facilities and amenities like gymnasium, swimming pool, badminton courts, tennis courts, and temples too. Living in an apartment has become very popular for its convenience. Living in the apartment has not merely remained a preferred housing option. It has become inevitable. Think of the nuclear families or senior citizens. They cannot live by themselves. If they live in the apartment, immediately they can get the services of the electrician, plumber, and there is, you see, security against the entry of outsiders till they get the approval from the inmates. I personally feel these days if somebody can live in independent bungalows or houses, it's only where 3 generations are living together. 3 generations are, if grandparents, parents, and grandchildren, they are living together, it is all right. You can afford to live in an independent house. Otherwise, living in the apartment becomes inevitable. The primary statute which governs the field in Karnataka is the Karnataka Apartment Ownership Act 1972, which provides for conferring upon each apartment owner an independent transferable title to a particular unit with an undivided share in the common areas. Common areas are handed over to the association only for the limited purpose of maintaining and managing them on behalf of the apartment owners. I read in the newspaper here and there that you see there is also a move to create duality of ownership. In my objective and humble opinion, it is legally not feasible. The question of conveying the title of the undivided common areas and facilities in favor of any welfare association or cooperative society does not arise at all. Friends, now let us see what are the major problems that the apartment purchasers and apartment dwellers are facing. One, more often than not, the developers delay the formation or creation of apartment owners association. And such a delay would invariably produce the consequence where the apartment dwellers have no bargaining strength with the developer and also with the civic authorities. You know that the developers often advertise premium amenities, for example, indoor swimming pool with a hot water, but they fail to deliver these amenities. Or if they deliver, those amenities would be incomplete or substandard. In the absence of the apartment owners association, the aggrieved individuals have to only go before the RERA or consumers forum. So the paramount need is to form the apartment owners association in the apartment complexes. Second problem, I learned some developers, they hand over the possession of the units or the flats to the buyers without obtaining occupancy certificates and completion certificates. If you occupy in the absence of occupancy certificate, completion certificate, your possession would be illegal and it exposes you to the penalties and potential eviction notices from the municipality or the corporation. The third problem is, which is very common in Bangalore, unauthorized alterations to the original buildings. That is, they make a departure from the building plan, such as converting the common spaces into commercial spaces, or adding some more floors, or putting extra units. Such deviation may lead to demolition of the building by the local government authorities like municipalities and corporations. Such issues would really diminish the quality of life for the apartment residents, besides imposing additional financial burdens on the owners and dwellers. Yet another issue which may be debated at some length is whether in the apartment complexes you have to have management committee of unitary nature or federal nature. That is, if there are 10 blocks or towers, whether there should be a management committee for each block, or you should have management committee in common for all the 10 blocks. There could also be a third model, 𝗪𝗺𝗁𝗃, that is, there will be one committee for each tower, and then 10 or 15 such committees would in turn have one centralized agency to take care of the general problems. So think over that. In today's workshops or seminars, this has to be dilated on. How to participate in the decision-making process, how to involve the residents at each stage of decision-making, how to evoke their sense of participation, shared responsibility, and how to ensure transparency and accountancy in the functioning of the management committees are also to be debated in today's proceedings. Friends, I can tell you from my experience, members of the management committee, some of them, they hail from very good background. They are senior professionals in their chosen area. They have good intents also. But they will not be having the practical experience to run the affairs of the apartment. So I'm just wondering whether Madam 𝗬𝗵𝗶𝗀𝗵 and her team members would organize the workshops for training the members of the management committee also. That is also required in my opinion. I sincerely hope the deliberations of this seminar will generate rich insights, honest solutions, and practical guidance for the lawyers and their apartment purchasing and apartment dwelling clients. I thank all of you for the patient hearing. I thank Madam 𝗬𝗵𝗶𝗀𝗵 and her team members for inviting me and showering so much of affection on me and giving me this opportunity to share some of my random thoughts with you. I would have loved to stay back till the end, only because of this pressing compulsion I have to live in the middle. Thank you everybody.
Thank you so much, sir, for sharing your views, your wisdom. Ladies and gentlemen, that was our chief guest, Honorable Justice 𝗺𝗂𝗶𝗃𝗍𝒂. Can I hear a big round of applause? Thank you so much, sir. What an honor. Thank you so much for taking time out to be with us, sir. Really appreciate it in spite of your busy schedule. Ladies and gentlemen, a big round of applause. Thank you for sharing your very valuable views, giving us a clarity on a very, very important subject. All right. Thank you so much, ladies and gentlemen. It is my privilege to introduce Honorable Shri K. Ramachandran, retired District and Sessions Judge from Kerala. A distinguished member of the judiciary, Shri Ramachandran served with great distinction as a District and Sessions Judge before joining the Kerala High Court Bar following his retirement. He holds a unique distinction of being the last district judge to retire at the age of 55 prior to the enhancement of the retirement age for judicial officers. Over the course of his illustrious career, he served as governing council of ILR Kerala and was a member of the Rules Committee for nearly 2 decades, contributing significantly to the development and administration of the legal system. He was also an active participant in the Lok Adalats and continued his legal practice for over 3 decades after retirement. Today, even after stepping from active practice, Sri Ramachandran continues to mentor and inspire young members of the legal fraternity through his vast experience and wisdom. Ladies and gentlemen, put your hands together. Please join me in extending a warm welcome to Honorable Sri K. Ramachandran.
Well, my friends, ladies and gentlemen, I thought there will be many dignitaries on the dais, but now I find only one dignitary who is the most important dignitary for this subject. Now I am asked to speak on something like delay in law courts and all that, because that's a subject which I can deal it with only because you forget about whatever I have served here, there and all that, because you score it off from your memory card. The experience, it is told, it is the best teacher. So far, I will confine my talk only to the difficulties of trial in the trial courts. Because for the big boss in the High Court, of course, I had practiced for more than 3 decades. Now I am withdrawing from that also, so served the High Court also in many. But so far as the difficulties of hearing in the High Court, I will not say anything, for because of my position in the legal field now. Now, so far as this difficulties of trial in the trial courts, I can share my thoughts with you, because I have been there for many years, from the Munshi to the district and sessions judge. And my legal journey is almost coming to an end, mostly because of my age and not because of that alone. Now I have come here mainly because of the pressure of my erstwhile brilliant junior, 𝗬𝗵𝗶𝗍. She was with me for a few years and she left me for her own good, without my knowledge, I may add. Now coming to the topic, trial, I don't know how many advocates are present here or how many retired judicial officers are present here. So whatever I speak now is only sharing of my thoughts with you. Now, so far as the trial is concerned, you know, this dharma I used to call is a chariot which has got 4 wheels. The first 2 wheels are the presiding officers and the lawyers. The second and third, the first 2, the third and fourth, behind the judges or presiding officers, there are the lawyers. Now behind the lawyers, there are the lawyers' clerks. Now so far as lawyers' clerks are concerned, they are diminishing community now because of the introduction of the new system, e-filing. I will not go to that. And their plight is not good or brilliant or pay, as that wheel is practically gone. Now, with use, now e-filing, the modern technology, all those things I am not going to say. Now, so far as the trial is concerned, it is the presiding officer and the lawyer. The other 2 important wheels of the dharma, the chariot. Now, so far as I will take up first the presiding officers, I do not know whether any retired presiding officers are here. You will bear with me if I say something. Now, so far as for that, what are their difficulties? Now, suppose a brilliant man, top first in the BL examination. Now you have got at least 3 years advocates practice to write for the exam, because for some time, no experience. You can straight away, after passing, you can straight away enter into the judicial field, provided you pass the examinations. Now that is 3 years active experience in a lawyer. That is there necessary. I will say I was canvassing for 5 years. Because to become a presiding officer suddenly by a lawyer, what does it mean? It means only you are a slave to your bench clerk, or what you say, what do you call here, I don't know, the court officer. You don't know nothing. You know only the text, the textual aspects. Can you hear me? Yes. I hope there is no problem. They can, there is no problem for hearing because some mic is out. Whenever the Chief Minister of Kerala comes, it is said that the mic will be off sometimes. Anyway, we will go on with the present device. Now, so far as the trial is concerned, that is the difficulty. Even if the brilliant advocate comes from a judicial officer, can he conduct the trial with the present system, speedily, expeditiously, efficiently, and justly? Think about it. Can you do it? Because there is some pitfalls, drawbacks, defects in the system itself. Pleadings have to come to him. Some statement is given. So I will cut short because there are enough speakers for you. So I will say the system has to be changed, and in spite of the change in the Civil Procedure Code, Criminal Procedure Code, and lastly by Evidence Act, and all this, and changing the name, it's not enough if the old wine is put in the new bottle. So that is there. Anyway, the system has to improve some more. There are many miles to go before the concerned authorities go to sleep. That's all what I have to say. Now, so far as the other thing is concerned, because I am given only 4 minutes, I think. Now, there is the introduction of artificial intelligence. It has come into play. Now, I have noted some points. I will read it because of paucity of time. Now, artificial intelligence, I will call it AI in quotes, benefits and risks. I am confining to trial, remember. AI can be a powerful aid to courts, but it should remain an assistant to judges, not a substitute for judicial wisdom and discretion. How AI can help courts? Faster research, instantly searches statutes, precedents, and legal principles, reduces the time spent on legal research. Case management helps classify and prioritize your list system, weekly list, daily list. Give it to AI, it will prepare. Then drafting assistance, assist in preparing draft orders, notices, summaries, and cost lists, not judgments. Improves efficiency in routine work. Handling large volumes of data. Now quickly analyzes thousands of pages of your pleadings, lawyers' pleadings, documents and evidence. Identifies relevant materials for consideration. Then translation and language support. I will just give the only points. Improved access to justice. How AI-powered legal information systems can guide litigants regarding procedures and filing requirements. And then consistency helps identify conflicting precedents, divergent precedents, and promotes uniformity in legal research. That is there. Then reduction of administrative burden for principal city civil court or principal subjects or even for principal sessions judges. This reduces administrative burden. How? Automates scheduling, record management, and document indexing. Then comes the more dangerous aspect, possible misuse of AI. Now I will say, hallucinated cases and citations means the lawyer cites some decisions reported in AR 1953 to Orissa, I forgot the page. No such decision. But if AI deals, you depend upon it. That is, it may invent non-existent judgments or misquote precedents. Now, blind reliance can lead to serious judicial errors. Bias and discrimination, another misuse. All systems may reflect biases present in training data. This can affect fairness and equality before the law. Loss of human judgment. Justice involves empathy, morality, and discretion. AI cannot fully appreciate human circumstances. I will cut short because warning is given to me. Privacy concerns, lack of transparency, over-dependence, cyber security risk, threat to judicial independence, all are misuse of AI. AI should assist, not decide. The ultimate responsibility for findings of fact, etc. I will, one sentence alone, artificial intelligence may help courts deliver justice faster. Only human intelligence and judicial wisdom can ensure that justice is delivered fairly. Now, thank you for patiently hearing me for such a few minutes. I would have talked to you for several hours, but the topic is so vast, a vast ocean, even the difficulties of trials in trials, a very vast ocean, and a very proper thing. And much is said about such things. More has been written on, but less, if not nothing, has been done to realize it. And there is a, Malayalis are here, there is a 𝗃𝗶𝗀𝗀𝗁𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀 also take leave after 10 or 15 minutes. And thank you patiently for hearing me. If you think that this has been slightly beneficial to you, I will take the credit. If you think that an old man has come from Kerala and spoke some nonsense, the discredit will go to the organization's function, excluding 𝗬𝗶𝗀𝗇𝗏. Okay, thank you.
Thank you so much, sir. Thank you for your time. Thank you for sharing your wisdom, sir. Ladies and gentlemen, a big round of applause.
Sir is aged 89. I just wanted to tell that.
Thank you, Beena. Thank you so much. Ladies and gentlemen, the enthusiasm and the need out here to serve the society at large at 89 is highly, highly commendable. Ladies and gentlemen, deserves your respect. A big round of applause. Ladies and gentlemen, without further ado, I now invite our next speaker, 𝗬𝗃𝗁𝗁𝗁, sir. He's the head of legal and chief general manager of MRPL and has an impressive legal career spanning 27 years. He's worked for many organizations like 𝗺𝗂𝗀𝗶𝗵 and 𝗬𝗺𝗃𝗁𝗁 before joining his current assignment at MRPL under ONGC Group. His performance as a general counsel was recognized with several awards, like the prestigious award given by Legal 500 in 2017, 2019 and 2022, BW Legal World Award in 2022, etc. Last year, in the year 2023, his excellence was once again recognized, being selected to receive the Outstanding General Counsel Award by the 𝗺𝗵𝗋𝗆 2023. He has perfected the art of being a top quality legal professional. Ladies and gentlemen, a big round of applause, 𝗺𝗃𝗁𝗁𝗁. Please welcome.
Heard Honorable Justice 𝗺𝗂𝗁𝗁𝗁, our Honorable Judge. Coming to the topic of today, this is supposed to be a legal awareness session for all of those who are caring about their living in a city like Bangalore. We all have come from different village backgrounds, or even the old Bangalore, where the life was so peaceful, life was in serenity. Today, we have our great city of Bangalore, famous for its traffic, chaotic living, and many more troubles across. I have experience of being a resident of an apartment, as also a member, a office bearer of an apartment association. So from both the angles, I could say there has been a lot of confusion among the residents, among the owners of the apartments and the associations. We have the confusion beginning from what association we have to form and how to manage a building. The builder has the expertise, but once the builder goes, we take over the maintenance of a massive building. It's not a simple building. It has thousands of people of varied character, varied jobs, different thoughts, and different backgrounds. The problem with the association and its office bearers is that we have to manage a big group of people. It involves a kind of HR job, people management. I would say in my tenure as an office bearer of the association committee, I felt that the maintenance job is fine, but it is more difficult to make people understand on each and every aspect of the maintenance. Many a times we say the job in a committee of an apartment association is a thankless job. We work for no remuneration. We work to hear scoldings, hear complaints, and do service for the fellow residents in our apartment. And the apartment owners never understand us. As an apartment owner, I always find some shortcoming with the committee. Committee is not taking quick action. Committee is taking very hasty action. Committee is taking no action. Any of these complaints can come with any minute problems in the apartment. Again, as an apartment dweller, I feel that the entire problem mostly comes from the handing over. We are not getting a handing over properly from the builder. Many times there are tussles between the builder and developer, builder and landowner, and finally it percolates down to the apartment owners in some way or other. How does this come? And the builder simply leaves. He doesn't guide us, he doesn't hand over anything to us. And we have to fight amongst ourselves. One segment of the residents want a charitable society as the association committee. Another segment wants a cooperative society as the association for the management of the apartments. And a legally understood person would say that it has to be an apartment owners association which has to be formed as per the law. then you will find 3 committees parallelly working for the maintenance of the same apartment. All these roots from confusion regarding the understanding of the law. Law is a vast subject, no doubt. As our judge was mentioning, there is a lot of things to learn in law. At the age of 89, he was trying to disseminate the information on artificial intelligence and its interaction with law. Law has been developing, it is always dynamic, and the recent amendment which has come up and the government's intervention has set right the thought about the management of the association, apartments. It has been now settled, very well settled, that apartment owners association has to be formed for any apartment, for the maintenance of that apartment. Then only a proper handover, then only a proper maintenance, then only the authorities for the association to collect maintenance charges, all this can happen. According to me, I would also, at this juncture, I would also thank Ms. 𝗵𝗵𝗶𝗀, learned advocate, who has handled a variety of cases on this subject and tried to get a clarity on the subject. Who has to maintain, whether it is a cooperative society or a charitable society or a apartment owners association as per the Act. So, her services to this particular segment of law has to be reckoned as a very valuable and precious service. And I would also say that in spite of her busy schedules, busy meetings and busy court hearings, she has been able to convene this kind of a legal awareness session for the benefit of all apartment dwellers and the public. This has been a commendable effort on her side, which she has repeated this year. Last year we had seen a very thought-provoking session, and she was able to deliver as we expected. And this year again, she has come up with this. This session, I am very sure that with the honorable dignitaries who are going to arrive on the dais, who are going to speak to you, further from Justice Hinjinagiri and our learned judge, are going to make you enrich with knowledge on the subject. And further to that, Ms. Advocate 𝗵𝗵𝗶𝗀 would be giving you a very good lecture on the subject, on the core of the subject. I am here to express my thanks for inviting me to this and giving me an opportunity to share my thoughts on this with all of you. Thank you to all the organization. Thank you all.
Moideen, ladies and gentlemen, thank you so much. Give him a big round of applause. All right, please welcome our next speaker, 𝗺𝗵𝗶𝗃𝗀𝗃, Governing Council Member of 𝗃𝗏. 𝗺𝗵𝗶𝗃𝗃𝗀𝗃 is a chartered accountant with over 25 years of experience in exporting outsourced casting and components. He also provides consulting in finance, marketing, legal, technology transfer and training both in India and overseas. He is a mathematics graduate from St. Stephen's College, Delhi, 1980 batch, and has been a past speaker at ICWI, ICAI and in the private sector. He's also served as guest faculty at IIM Bangalore in finance and marketing. His journey with 𝗏 began in 2021 as a 𝗵𝗶𝗀 Cluster Council member, later serving as the secretary of the cluster. Since January 2025, he has been serving as a governing council member, contributing to several successful initiatives during his term. Ladies and gentlemen, allow me to enumerate his vision and focus areas for 2025-2027, working towards eradicating legislative bias against vertically stacked flats classified as bulk generators/consumers, establish a 𝗏 training cell to conduct paid RWA management workshops in newly completed projects, build strong relationships with apartment association federations in Karnataka and across India, contribute to drafting a digital electricity grid for 𝗏 members to enable renewable power and carbon credit training, and also support drafting of the proposed KAOA rules, drive growth of 𝗏 membership by 5,000 new members. Ladies and gentlemen, 𝗍𝗵𝗏, put your hands together, welcome him.
People start the session with thanks to a lot of people, there is a lot of formality, and that's how we have conducted our life. Whereas I possibly was influenced more by Pink Floyd, whose famous song said, "Teacher, leave the kids alone." If any of you have a time, please go back and think one of the biggest problems and challenges which we have is in our way of thinking. And we never do what is called as a root cause analysis. Why have we landed here? What brought us here? So let me share with you 2 lines of wisdom before we start and get into the presentation. If you can understand that, you have understood everything. First thing is, we are lucky and fortunate that in Karnataka, we have a patron saint who is dedicated to the construction and building trade, who has not been recognized by the building and construction trade or the government. Please give a big hand to Lord Purandradasa, who said, "Idilla nammane, ade nammane." Please build on it. I'm not a Kannadiga, I can't understand, but I've understood what he said. But we are fighting for this money. Please think about it. If you can't live as a community, etc., Purandradasa might check and ask you, what did you do in your community? This record is something which you have to see. Now let's understand the other logic. We have only one way to evaluate purchase propositions. The government has wonderfully taught us, go for the lowest cost tender. When we try to buy property, we go for the obvious, as many square feet as possible for my budget. Have we thought, is water available? Our power is available? Permissions are available? No. Where we get a 1 BHK in Prestige or whatever it is, I can get a 2 or 3 BHK, so I'll buy that. Now, who is the root cause of the problem? It's our thought process. So please pay attention to your own thought process, and further, this gets escalated as we go into maintenance. Again, the same philosophy applies. So we give a buy. If there is a fire, your fire tender cannot arrive. Please think about it. Your roads are narrow. You've also over-constructed, so there is no chance that you will reach. If I may say so in black humor, please don't pay insurance. It's not worth it. You only made the insurer rich. Before going, please do pray and ask the gods whether they'll give you at least some good karma credit for having paid the insurance premium. So this is the background, and surprisingly, this coexists with a community which also claims that we can deliver the extremely complex projects for the rest of the world. To give you an example, Zurich Stock Exchange had to do a change of systems live, which meant that they had upgrading their systems, and people who were trading, who were placing orders, who were buying and selling, did not notice that the system has changed behind. Who did this? TCS. This was done maybe 20 years ago. How is it such intelligent people who can do so many things in so many fields? TCS was only an example. We can send the moon to the wrong side, our rocket to the wrong side and make it land on the moon, but we are not able to fix our association. Who is responsible? And frequently we keep on cursing the law and its draft. It's poorly drafted, it is this, it is that. Now, we have a golden opportunity here because there is a new act which is coming in. For the first time in the Karnataka Apartment Ownership Management Act, you have the chance to participate. Please use this opportunity for the first time because we can collate our opinions together and create the law which we want. Create the transparency which we want. Please also remember, it's very easy to keep looking amongst ourselves and understand the shortcomings of our community. Have you ever thought, we all speak about this term called drip irrigation. How did this come about? There was a small kibbutz in Israel, and there was a gentleman called Simcha Blas, who one fine day found one tree growing better than the other trees because there was a broken pipe by its side. That was the start of drip irrigation. A global giant was grown by that community. I guess they don't have to pay maintenance to their community. Are you able to understand the implications? If all of you who are standing divided stand together, you could even create a business which would change the world. You have the brains, you have everything, but you finally come and stand here saying, the dog has bitten me. Let's go to the police. X made noise. I don't know. I have no answers. As a mathematician, I can even tell you, Serge Lang, one of the biggest professors of algebra, wrote a nice small note on how vitiated elections can be, and you end up with the undesired result because some candidates came in between. They cut into the vote bank. So there is a lot of history. And there is a lot of things which we have to look at before I started and gave you the presentation. And that's why I decided first to speak to you heart to heart without getting into thanking you for sitting and listening to me, etc., etc. This is the standard, sorry to put it, BS which we have been given for a long time. I'm a strong believer in not only Floyd, I also remember Strawberry Fields, another famous song from Beatles. Nothing is real, nothing to be hung about. Strawberry fields are forever. It's a pity that we seem to read all this, sing all this, but when it comes to real life, we are struggling as though we are flies which are caught in a thick soup. With that, I'll request my friend here to quickly take you through a journey of what has happened on KAOA. Basically, the first problem which we have is, let's understand the new act is planned. It is basically like engagement has been announced. The marriage date has still not been fixed. Yes, the government is talking of allowing it to be happening by this monsoon session. I hope it goes through. If it goes through, it's still the first phase because after that comes the rules. After that comes the actual implementation. We all need to participate and look at this as an opportunity to participate, and let's not behave like the usual cattle classing. They have done the mistake. Please read every little bit, come back, and let's collectively voice our opinion and make the bill which we want. It is possible. Others also look at social media. Please collect your opinions and put it across like a good set of people who are well-managed, who are professionals, which we have heard of. We can create the law which we want, and it is possible. So now, let's understand why we say Karnataka Apartment Owners Act is the right act to register as on date. It is because of the fact that it creates an inheritable title which can be transferred. If you were to look at KSRA, it's meant to promote objectives like promotion of sport. It doesn't allow you to maintain a building. If any member of a society passes away, membership does not automatically mean title to the common area passes on. That is the real difference. Similarly, when we talk of Cooperative Act, many people think that's the way to go. Please understand, Maharashtra has a separate Cooperative Housing Act. We do not have. Do you want to work along with the BD workers? I'm very happy for you. I'm sorry, I am not used to speaking softly and nicely. All through my life, I have learned the guy who speaks only gets soup. Dickens was the man who wrote about it. I'm sorry, I have learned always to be that child who asked and said, I want more, I can't live with what you're doing. In fact, the man who got me into BAF is there in the audience, and my president, Satish Malaya, they were tolerant of me because I asked some absolutely abrasive questions, and they decided it's better to put me on this side of the fence than the other side. And I humbly acknowledge their contribution. Now, if you were to go into the next step which is there, beyond this, we understand that we don't have the right act, and the main problem is Karnataka Apartment Ownership Act is silent on reconstruction of the building. Maybe in '72 when we built the buildings, there was no need to consider or think, will this building ever collapse? I also hope it doesn't collapse. I'll allow you to think about it. And in case you have interest in ethics of construction, please go back and see about a Professor 𝗺𝗬𝗀 who constructed a building for Citibank in New York, which was its headquarters. A student, after the inauguration of the building, said, "Sir, you seem to have used your knowledge to build a building which never considered the winds which are blowing in a diagonal direction. Route 2 of the wind would have decimated the building." That student was right. 𝗺𝗬𝗀, post-construction of the building as an architect, went back to the city authorities and said, I think there is a flaw in the building, called his biggest opponent and challenger and said, you also sit in the committee and let's find a solution. I leave you to get into the details of it by yourself, but the point is, which Indian professional do you think post 2-3 years of construction will come back and say, I made a mistake? Will anyone raise his hands and acknowledge it? That is professional. The only other profession which has worked well in life as a chartered accountant, I will humbly acknowledge those who worked in the oldest profession. They were also far more truer. If they were paid, they just rendered their services and left. Let's not speak of all other versions which came in between. This may be absolute a crime to say this from the stage, but this is the true state of our affairs. Let's continue further. Now, whenever anything is promoted, the promoter only looks like playing a game of relay race. He just wants to hand over and vanish from that moment. Why? Should there not be a connection with the architect, with the builder, and others for a lifetime? Why is it we are fighting shy of building a relationship and talking of them as partners? If the building stands for 25 years, would you ever like to call your original architect and ask him, why did he design the building this way? You can do it, and you will get some interesting insights at the end of 25 years. Please look at building these relationships rather than, if you were to look at it, please tell me honestly if I'm wrong, maintenance of a building is far lesser than 0.5% of the cost of the building. If you can buy something for 1 crore, having bought an elephant, why are we fighting shy of paying the right bills? You don't pay the right bills, you can't get the right people, you don't give them peace to run the operation, how do you expect them to survive? The simplest thing is, please remember, any person can run a successful business, but when it collapses, you need an intelligent person. He has to create a cash flow where there is nothing. Why do you want to put this pressure onto your own people? even if you have a protest, let's protest like the Japanese did. If there is a reason to protest against management, in a shoe factory, they decided they will only make the right shoe and not make the left shoe of the pair. But production continued. Can we not pay our maintenance and protest peacefully? I'm sure some solutions can come out. Every monkey can be skinned 10 different ways is what I believe I've read from the Chinese. We don't like the Chinese, but at least 2-3 ways we can skin the poor animal. So let's look at it that way, and let's look at law and everything in a participative, different fashion than you versus me. Let KAOA be the first act in which dispute pendency is reduced to 90 days, nothing to go beyond that. Is this something which we can collectively find a solution? Let us prove that in this country there will be no pendency of cases. Put it as a lofty aim, maybe you'll hit 50% of it, 60%, but if you still manage to even close all issues within a year, would you not agree we have done better as a judicial record? What's your opinion? I see all of you silent, which means I as a teacher will have to leave you alone. Unless I hear your noise, I don't know whether you're with me or without me. Please, and please remember, what you have here is like a short marriage which has happened with a promoter. After that, honeymoon, wherein he also will give you maybe a visit, maybe even take you around to a golf course to play golf. At the end of it, he says, this is real life, start living tomorrow. KAOA is also similar to it. Please think about it. Then, when you move away, the basic problems which we have, which we need to look at, is to enforce maintenance arrears collection. This is a problem wherein people feel if they hold the check, they can get the society to be run the way it needs to be run. I differ with it. Pay your money and protest saying you're paid under duress and get your work done, because if you hold back money, you're not doing the right thing. If you can't pay for your water, if you can't pay for your electricity, then I think time has come to relook at which are the books of religion you study and what is your philosophy. Something is wrong. No free lunches are there, and please stop looking for free lunches. You have a cost to pay it. Walk with dignity. Do not descend to this level of fighting, because it's very unfortunate to say, I thought that if flats are higher priced, the community will be well run. No, there are more legal notices which are sent even faster than you can go down the lift. Please think about these factors and please look at it. And the other thing is retrospective change in maintenance. Everyone likes to cut their bills. So someone says if it is per square foot, let us head for flat fee. If it is flat fee, let us head for this. And recently there was a court case which was held, and I'm very interested to share with you the details. In that particular case, there were 440 apartments of 3 BHK and 40 or so apartments of 2 BHK. It was a separate tower. The 3 BHK guys decided, they were in management, to go and fight the case in the court and saying that henceforth maintenance which is there has to be done on an equitable basis. That means it will be shared irrespective of the size of your apartment. Wonderful. The management and the litigants who went in were all 3-bedroom, and I'm given to understand even the lawyer who appeared for them had a 3 BHK apartment. Now the whole system is silent about this, and we have changed our form of maintenance. They filed 2 cases. In one case, they gave their deed of declaration, they lost the case. Second case, they filed in an adjacent civil court, they won because they had not filed a deed of declaration. With this kind of impunity, if people win cases and we all start arguing, equated, per square foot, equated, all I can say is all of you would ensure that there is good employment for 2 chartered accountants in your basement to calculate the arrears, interest. And we seem to have forgotten some flats were let out in between or sold to somebody. You have given him a certificate saying that there are no dues. Who will pay for him? These are physical, practical questions, and unless you understand, we need to stop looking back and turning the clock and saying, hey, you know what? We sat for a meal, you ate more than me. It's over. The meal is finished. Everything is over. Please start looking ahead. Then, if you look at it, maintenance, there is no discount if the flat is closed for a long time. I think this is absolutely absurd. At least water is not consumed. Should there not be an open declaration of leave of absence for, say, 90 days, whatever it is, and association can monitor and let those who consume the water pay for it. The principle of environmental law is polluter pays. The simple basis of economic principle is the man who had the meal has to pay for it. Whoever has not taken should be let alone. Why are we fighting these kind of things? Because we like a free meal. How different are we from those people whom we look down upon, who collect freebies from the government? I'm sorry. This is how bad I feel about it. Similarly, when it comes to discrimination, this morning I was in one of the best run apartment complex, but I was shocked to see service staff came into the lift along with the owners. One of the owners rebuked those people saying, how dare you come into the lift? Let me ask you guys, do we have to have a Sabarimala case here saying they're also entitled, or do we need to bring Gandhi and others back to say they are entitled? What kind of a mess are we creating? We are still continuing with such classification. Who are they helping out? You and me. You do this in some countries like Sweden, you would have been behind bars before you closed your mouth. This is rank discrimination. How can you expect people who come and help you and serve you to walk silently behind because they don't have 2 crores? I'm sorry, this is our average behavior, and unless we change it, any amount of law and rules will not help us. There are a lot of educated, erudite people on this side. We blame them for poor laws. How can they help us when we are built like this? You think we can hold them responsible? Please think about it. Then, the last thing which is here is, whenever you create an open repository of data, today we have a challenge to see what are the records of the association. Who has paid, what are the legal issues. The auditor does not say what are the legal issues, what are the issues between apartments. Supposing there is a leak, the best way to sell the flat is to cleanly whitewash the whole place. Those of you who have read Tom Sawyer would accept that this is the best way to sell the flat. Please go back and read Whitewashing the Wall as done by Tom Sawyer. Those of you who have not read, please go back. It's an epic in terms of selling. His mother told him, you cannot whitewash the wall. He said, I will do it. His friend said, what stupid work are you doing? He collected and cleaned them out of the cat with no eyes, marbles, everything, and he was sitting in the corner because others were wanting and vying to do the painting of the wall. We paint the wall like this and we sell our flat. It's written that in case you commit any deficiency like this, you are responsible. Have you ever challenged anyone for having sold you this kind of a flat? Worse than this, electrical installations which are there, the wires and insulation, after 15 or 20 years may have gone down. We never seem to collect a certificate from an electrical engineering saying it's safe. We are more bothered about Vastu, we are more bothered about title deeds. I suppose we must admit we like to get purified by Agni. Let this be understood, because this is our rationale to even handle fire hazards. Please look further. Ensure from day one, whoever is dealing with the Karnataka Apartment Owners Act open repository, I request the government to make sure each and every official has an official email ID, not a Gmail ID. And their list of mobile numbers and everything is openly put out so that we start from day one having clarity whom we should approach and how we should file the complaint. Then comes the next thing. We need to also have a digital way of filing these complaints. I don't think it is any longer a new model which we are ascribing for or prescribing, because today income tax hearings and other things are happening digitally. Why can we not file complaints or sort out issues digitally and appear for it? This is something to be considered. And we need to have a comprehensive repository in which we can access data and we can also share better quality data. Then, so more than elaborating on the presentation and saying how a digital backbone should be created, I would rather prefer you to think, collect this presentation from the organizers and go ahead and add your points and see how we can create a proper repository of issues to be resolved, and we go ahead. It is more participative than having one person stand in the front and claim he has all the wisdom. I don't have. I definitely do not have. And what happens is when you link your records digitally, water consumption and other things can be known perfectly, and why should there not be disclosure of the fact whenever your apartment bought water by tankers, should it not be disclosed to prospective buyers? Why should they think water is coming, Indra is happy with us, and when you come in, you suddenly realize only you have to do more pujas to get the water? There's something which is very strange. We like to hide original detailed facts under a thin veneer of boiled rice and hope that nobody spots the pumpkin. There's something to be seen here, right? And when we are talking of a legal transition pathway for existing societies which are registered, let it be pointed out that the Income Tax Act and the other acts which are there have not even heard of this problem. When you transition, then you'll realize they'll come with their demands. So the government should prepare and make sure that there is a proper way of creating a structured pathway. It's like you convert a company into a LLP or LLP into a company. Some of these things need to be thought through. Yeah. See, the biggest other challenge is you come and say this is a thankless job. Let me try to change it and look at it. What did I learn from coming here and asking questions or doing things or running things in my own association? I learned to interact with the politician. I learned he also brings something to the table. I'm happy to say all people come for happy occasions, but my politician, I stay in the constituency of Mr. Ashok of BJP, Padmanabh Nagara. And when we had COVID, there was death in a family and they were also under quarantine. The team, after a phone call, within 4 hours, managed to dispose of the body. Isn't this service? I'm not a fan of any party, but I've always told one thing to him and his people. You change the color of your party, I will still support you. We need to grow up, we need to interact and not keep on saying they're all corrupt. They're all corrupt. That's not the case. Please reconsider and also remember one more thing. Our current act says arrest first, investigate later. This doesn't work. This has to change because when you have a swimming pool death or anything which happens in the apartment, we are held responsible. Are we really responsible? Is a question we have to ask. Then, whenever you are planning for any apartment issues, I said, let us have self-governance. Let there be, for the first time, disputes heard by KAOA officials along with some people who have experience in apartment management, and let us close our complaints as soon as possible, then drag it further and further. We need to join BAF to work together. The fee which is there, joining fee, is barely about 50 rupees per year per flat. If you're a small complex, larger as a complex grows, it's only 5 rupees. Please join hands because, frankly, the more we stand together, the better off we are. But we often seem to fall on a very interesting English definition of community. KAM, unity. Kam hi hai unity, usi ko hum kehte hain community. Please think about this wonderful definition. So as I said, it is just to give you a bird's eye view of what should be done after enactment of KAOA. And there are a million issues more than what I can put in any PowerPoint. Please join hands. Please raise your hands and commit that you will join and participate and not blame N.A. Harris and others after 20 years. I don't think any of these people are responsible for the chaos, because when feedback had to be given, you were not there. Thank you. Sorry.
Check. Thank you so much, sir. That was so passionate, ladies and gentlemen. He spoke straight from the heart. Give a big round of applause. It's very colorful. I'm surprised you had to invoke the Beatles, the strawberry fields, and 10 different ways to skin a monkey just to prove your point, and a point very well made. Give him a big round of applause. Ladies and gentlemen, it is my privilege to introduce Shri Rajendra Kataria, IAS Additional Chief Secretary, Revenue Department, Government of Karnataka, a distinguished 1996 batch IAS officer of the Karnataka cadre. Shri Kataria brings with him nearly 3 decades of exemplary public service. Over the course of his illustrious career, he has held several key leadership positions, including Managing Director of KSRTC and Principal Secretary to the Agriculture and Sericulture Department, besides serving on Central Deputation. Today, as Additional Chief Secretary of the Revenue Department, he oversees one of the state's most critical departments, dealing with land administration, revenue governance, and matters that directly impact citizens, property owners, and residential communities across Karnataka. His dedication to public service was recognized internationally when he was awarded the Star 2020 certificate by the World Book of Records, London, for his outstanding contribution to the society during the COVID-19 pandemic. Ladies and gentlemen, please join me in extending a warm welcome to Shri Rajendra Kataria. Big round of applause. Unfortunately, he could not be with us in person. Ladies and gentlemen, he'll be joining us online. All eyes on screen. All right, we apologize for the inconvenience caused. Ladies and gentlemen, let's move on to the next speaker before we are able to connect. Are you able to connect? All right.
Delegates, all the dignitaries, and all the participants, students and friends. I hope I'm audible to all. I'm really sorry for not being here physically because of my last minute urgency, some commitment which I had not anticipated. I'll just focus on, since we are talking about the land governance, since I handle the subject land. Land is a state subject, as you know. Land and land acquisition, land registration, these all are handled by the state governments. So in Karnataka, I'm there for the last 3 years, and with my experience in the last 3 years and my past experience in various assignments where I have handled land. Land is a very critical, part of our ecosystem. Historically, if you look at the land ownership and the land titling in India, it is not very absolute, very clear. We are basically continuing the survey which was conducted by the Britishers when they were ruling this country. So in the entire country, various parts of the state, having worked in Haryana and now in Karnataka, so with that wide experience, I am sharing that the land survey was conducted by the Britishers at that point of time. The whole aim and object was basically to collect revenue. And the ownership came very, very late. The ownership in Karnataka and many of the states are still a subject which are debated. Now, if I look at Karnataka, how the land from survey to the ownership started. If you remember, during the Second World War, when we had severe food shortage worldwide, so that time the concept came that there is a land which is barren, which is uncultivated. So that land was offered under grow more food, that people can convert that land into agriculture and then start doing cultivation. And then subsequently, after a few years, then government offered them, if you want to buy the land, pay some money and buy that land. So that was the first of kind ownership. Second was, like, as you know, that most of these lands in the entire country, actually, the state was the owner. Subsequently, with the state was the owner, this under various reforms, land reforms act, like in Karnataka, but particularly, we had land reforms act in 1961. Then we had various Inam abolition acts. So the entire land in Karnataka, various part of Karnataka, there was huge Inam lands. given to the inamdars, the jamindars, the jagirdars who were basically supporting the then government. So these people were given large chunk of land. Some of the inamdars had almost like some 30-40 villages, maybe more. Some of them in fact had the entire district as their ownership. So when the land reforms came, so that time the ownership was given to farmers, basically the land to tiller. Basically people who were tilling the land, who were cultivating the lands were given ownership. In Karnataka, the documentation of land records, somewhere in 2099, when I joined service in 96, 97, that time this Karnataka state was the first state where the records, land ownership records were getting computerized. So in 2002, in Karnataka, what we call is RTC. RTC is basically R stands for record of rights, T is basically tenancy, and C talks about crops. So there is a table where the various elements are the name of the village, the location of land, survey number, his number, type of land, owner, the physical to digital, electronic. From that time onward, which I am noticing in the last 3 years, the land ownership has become very critical because especially like in city like Bangalore and around, the land is very, very limited, and of late people are very, they have started creating fake records. So in the last 3 years, we have referred almost a few dozen cases. When we doubted that there are documents being fabricated, people have inserted in the file, and when we started sending these documents to the forensic, then we realized that many of the fake documents are there. So and then the records are also getting very old. Some records are more than 100 years. So 2.5 years back, I'll just highlight 2-3 main initiatives the state of Karnataka has taken to protect the old records and to sanitize the ownership records. So in Karnataka, we took one stand that there are almost close to more than 130 crore pages. Records are lying in roughly 240 taluks in 31 districts. So we took a stand from decision that let us go for digitizing these documents. So as of now, close to 81 crore pages we have digitized. 131 taluk offices, tehsil completely we have digitized, and now we are also digitizing the assistant commissioner office and deputy commissioner office. So once this digital process is complete, the ownership records cannot be altered about the land is concerned. So that is one part. Second part is, in southern part, we have in a particular piece of land, you will find kharab lands. Kharab are A and B type of kharab land where the government has the ownership or private people have the ownership within the part of a private land. So that also, and then there are government lands. So there are cases where the government land is sold to private people by fabricating the documents. So from the government side, we started a concept 2 years back, a land beat. So we developed an app. It's called Land Beat app. During the British time, so these Britishers used to visit the important installation on a regular basis. Police also do now post-independence in the police beat. On a similar line to protect the public land, government lands. So we came out with this Land Beat app. Almost 14,37,000 government lands are there in the state, which are owned by my department, by Land Revenue Department, and most of these lands are either the raw big piece of land or the public lands, which are used as roads, or drainage, channel, and parks, and for the grazing in the villages, grazing yards area, or the burial grounds. All these lands, to protect them from encroachment, and also to protect them from any kind of manipulation, mischievous activity being carried out by people. So we started mapping this area. So all the lands, 14 lakh and odd lands, we have physically our people have gone because it's a geofence. So we have done the survey, and that entire land has been mapped. And in our 𝗺𝗵𝗎 software, 𝗺𝗵𝗎 is our land record software in the state, and 𝗺𝗵𝗎 was the first of its kind in the country in 2002 when we came out with the 𝗺𝗵𝗎. That was the first in the country, and that entire country has adopted Karnataka model now. Now the records have been digitized. All the land owned by the government. Most of it have been flagged in the system, so the mutation will not happen. Transaction, sale or other activities will not happen now. My sub-registrar will, because the system will not allow to fetch. Now, the important thing since we are talking about the ownership, apartment ownership, but since I handle only land, so I'll focus on the land. So the land transaction, now if you have to go to Bhumi, or suppose if you go to sub-registrar office, so the sub-registrar office will not rely purely on what document you are presenting. Now we have linkages with three main databases. We have Bhumi, which handles the agriculture land. We have 𝗃𝗃𝗃𝗃, which handles the urban properties. And then we have 𝗃𝗃𝗃𝗃, which is basically panchayat, rural property database. When you go for registration, so my system will actually fetch data from these three databases. It will not rely upon your information, what you supply. It will cross-verify digitally to avoid any information or manipulation. On top of it, in Karnataka, we have close to 2 crore land parcels owned by almost 3.89 crores people. So 3.89 crore people are holding ownership of around 2 crore land parcels. So to avoid any kind of duplication, we started 2 years back Aadhaar seeding of these land parcels with the owner. And I'm happy to say that almost 89% of the land parcels have been now seeded with Aadhaar. So that if any transaction has to happen, it will through Aadhaar authentication. So that has actually reduced the impersonation or any kind of manipulation. So that is one thing which the state of Karnataka has done in the last 2 years. So that has sanitized the ownership record. One issue which I like to highlight, that when we grant any land, I mean, if you want to buy a land, there are few restrictions in the land transaction. Like if there is a land granted to any 𝗪𝒽/SC. So there's an act in Karnataka. It's called Karnataka 𝗪𝒽/SC prohibition of certain types of lands. We generally call PTCL Act. All the lands which are granted to 𝗪𝒽/SC, agriculture land, cannot be transacted, sold to any person without the specific permission of the government. So in each case, it requires a government permission. So in my office, we give permission on case-to-case basis, because the idea was, when the lands were granted to the 𝗪𝒽/SC, that the family is a source of income and survival for the family. So the source should not disappear. It should not go. People should not forcibly or otherwise take away this property. So we have some system that if you are disposing this piece of land, then buy some other piece of land, so that your dependence on agricultural activity continues with another piece of land, and then you are carrying out certain economic activity, and you are able to feed your family and maintain your whatever standard you are maintaining in the habitation. So that is one part. Secondly, if any land is granted to any person in state of Karnataka, so there is some restriction for number of years. Certain lands are for 15 years and certain land parcels are for 25 years. So within this period, there is completely no possibility of alienating that land to any person by any means. As I was saying, PTCL is a complete ban. You need a permission. In the second category, there is a complete restriction during this specific period. Again, only government can relax those conditions, but generally we don't relax these conditions, because we don't when we grant land, it's granted for a specific purpose. So that is the second part of it. Third thing about sub-registration office, just let me just tell you, we have basically sanitized our operations. Generally in India, people talk about high level of corruption in the sub-registrar office or in the tehsil office and all that. So to remove that kind of image and to bring transparency, to basically make system better, we have now last 6-8 months we have tried hard, and now the land registration, whether it's registration of apartment or land or any other property, so you can apply online the SRO will examine your paper online. If the papers are found to be okay and your fees calculation is done as per the statute, then he will say yes. He will indicate he or she will indicate the amount to be paid as stamp duty and the registration. You pay the money and take a date. On that scheduled date, you can go and you can register. In Bangalore, you can register anywhere, irrespective of your area, irrespective of your place of residence. So there are a number of SROs in the city of Bangalore. There are almost more than 240 SROs office in the state of Karnataka. So you can register anywhere within the district. Now we are trying and expanding it anywhere in the district. So I mean anywhere in the state. So that pilot is going on. One more thing which we have done is by rotation, one office in Bangalore, we are trying to work on a holiday, so that people who work and who are not otherwise available, they would prefer to be available on a weekend, on a holiday. So we are also doing it by rotation. Every week, one office in the city is opened on a holiday, so that people can actually register their property. So that is a good governance measure from the state of Karnataka. You want 𝗍, you want land records, they are available across the counter. You can nowadays, you can apply online, you don't have to visit any government office, and you can fetch this information. And we are trying from our side to make system as transparent as possible. There are, for your kind information, just to share, I mean the department, the maximum cases, if you, most of you are from the legal background, or people who are organizing this event, and I am sure people in general would like to know. Just give a small figure. In 2023 and 24, 25, 3 years, I collected some figure as to how many writ petitions are filed against this by the people. Generally, writ petitions are filed against the state, against people like us. Out of that, 40% of the writ petitions were against my department. They were land-related issues. So the dispute is very high. Second, I recently been to 2-3 districts, and I had happened to interact with my friends in the judiciary and also people into the profession. There's a high number of cases. More than 60% of the litigation in the civil courts are pertaining to land. So that starts with the ownership of the land, with the location of the land. Now coming to the location of the land, we have, in the last 2 years, we have something called all the survey lands. We are doing now geofencing of land. So we are surveying the entire state using drone-based technology. So there's an aerial survey, and then we are using high-tech rovers. Rovers is basically an instrument of measurement of land, and these rovers are connected with the satellite. So now in the Karnataka, we are the leader in the country now. Karnataka, we have started using rovers, and the rover is helping us in connecting and giving the right accurate information about the property. In the urban areas, for measuring the properties, Bangalore doing something called UPOR, Urban Property Registration, which is now we are merging with e-Khata, so that your property location, type of property, there's a photo, 2D and 3D photos are captured, and you can re-verify before you buy or before when you do any kind of transaction. So that is one thing. And for each property, we are giving something called ULPIN, ULPIN, unique parcel land identification number. So for each land parcel, we are also giving a unique number, which is basically automatic number which has some calculation. So you can, with that number, you can actually find out the location of the building on the globe. So that exercise we have started. And lastly, as best international practice, there's something called land stacking. So that concept, that how this apartment has born, from where it has come, or how this land parcel is from where it has come. As I was mentioning, the original survey was done by the Britishers in pre-independence. It was done 1815 odd. So on that survey map, the accuracy we have measured, on the survey map we are putting different layers, so that you can, tomorrow if there is any dispute, especially like in the periphery of Bangalore, a lot of agriculture land has been converted into non-agriculture, and it has been converted into layouts, or apartments have come in, and you will find thousands of such cases are before the court where the land is under dispute about the titling of the land or the location of the land. So now with the land stacking model, which we have just started, it will take some time to become a reality. But we have started that where the base survey map, on that survey map, we are putting the layout plan. On that layout plan, we are putting your plot. On the plot, we are putting your apartment. On the apartment, we are putting your all kind of utility connection, so that when you click on, it will happen soon, when you click on the apartment location or the apartment or the area, you will get to know what the total land is, from where the land has originated, which survey number this land belongs to, who are the original owner, and how the ownership has changed over the years. Number one. Number two, how the layouts have been, permission was taken, how the plan sanction was given, how individual ownership was transferred, and then how utilities are connected to those individual properties. So this exercise is going on. I think this would help any person in very soon in future to basically verify about the genuineness, legality of the property. So that will help everybody. That is from the revenue department side, government of Karnataka side, way forward. And the last final word, we are also coming out with something called ULMS, Urban Land Management System, where all the, as I was saying, land stacking. So it's a model of land stacking. So in the blockchain model, all the databases will be connected so that any citizen can fetch information about any property before one buys or one transacts. I think from my side, I want a few ideas of the state, what state has been doing. I've shared. If anybody has any question, may ask any question, or else I'm done from my side. Thank you. And I especially thank all the participants and the organizer for organizing such a workshop. I think the awareness programs are really essential. As I was mentioning, the highest number of litigation in the state and maybe in the country are pertaining to land. And sometime or most of the time, it is because of the disputes arising about the location, ownership, and of late, especially in case of, I think I missed one subject about RERA. In case of, like, there are a lot of RERA cases. I also handle RERA recoveries, basically. Investors, they invest money in an apartment, and then the money is diverted elsewhere. So that thing is also going to be part of our ULMS model in future, when a person, a probable buyer, will get to know what kind of layout plan has been sanctioned, how many plots or how many apartments have been permitted by the planning authorities, what is the height, what is the width, what is the setback, so that you know that all the parameters, all the norms of the government are followed while executing the project. And then there's a timeline for completion, because each builder, developer would have given some timeline to the RERA authorities before taking permission, so that you can also follow that what is the timeline for a developer or a builder to complete that process. Once the process is done, then if you know that there is a delay, so at the right time you can knock the door of the either RERA or the builder, so that you know that your money is not diverted elsewhere, and then the builder is not taking away your money, running away from the ground or diverting the money elsewhere. We do recovery of such cases. So those cases are also be part of it. So this ULMS platform which we are coming out with will also take care of the RERA. We are having a linkage with the RERA. So another maybe 2 or 3 months time, this will be rolled out in the state of Karnataka, and we will be the first in the country to come out with such a model. Thank you, everybody.
Thank you so much. Ladies and gentlemen, Shri Rajendra Kumar Kataria. Can I hear a big round of applause? Thank you. Ladies and gentlemen, please welcome Shri Rakesh Singh.
Good afternoon, respected Harris sir, Ramesh sir, Satish Malya, ladies and gentlemen. I am Rakesh Singh. I requested that I'll introduce myself. I am Rakesh Singh. Presently, I work in RERA. I'm RERA chairman. Just to start with, I'll thank Ramesh sir for giving such an illustrative presentation, and then the talk by Mr. Kataria. In last 2.5 hours, the things have become extremely serious. In my personal opinion, the issue is not so serious. It's not so complicated. It's very, very, very easy. And when I say that it's very easy, what I'm exactly talking is that once a promoter has started a project, what the home buyer wants, that what is assured to him should be delivered in a given time frame with all the assurances. Sometime around 2013-14, because of some experience in Delhi, this organization called RERA came into being. It has been almost 9 years. At the all India level, the number of complaints must be few lakhs. Most of them have been deliberated and answers have been found. And now the realization is that this act requires some midway corrections. So while talking to you, and what Sir presented is basically about the Apartment Ownership Act, that has almost the entire discussions aspect has been completed. It was to be placed in the last assembly, somehow it did not happen. Most likely with the new Honorable CM and with the initiative of Chairman BDA, in the next assembly session it will be cleared. But my quick and small point is where I started. It's not so complicated. What we were talking about, that once the project comes in the hands of association for the purpose of maintenance and other things, Sir talked about UDA, Sir talked about reconstruction. These aspects were new to Karnataka, where in Maharashtra it was always there. But basically it is a small transparency that is required at the government level, at the promoter level. The promoter finds it extremely difficult to get his project cleared at different levels, be it the planning authority, be it different government institutions, be it RERA. Once these institutions, if they start working in a little more people's friendly or in a little more transparent in a given time frame, there is no reason for the promoter to in any way rub the allottees, because for a promoter it is not one-off project. He wants to do project after project, project after project, and this is only possible when they get the right reputation in the town or the state. For that, the government, the allottees and the promoter, we all have to come on the table, which is again repeatedly I am saying it's not very complicated. Before coming to you, when I was talking to Chairman BDA, I was requesting, Sir, that all these things what I am talking is easily doable. It is not at all complicated. Once it is easily doable, I think there has been a little less effort on the part of people like me who have been in government for a very long time. With the help of the present, the new CM, Chairman BDA, on behalf of them and on my personal behalf, what best is possible will be done shortly. When I say shortly, I'm not talking of years. We'll try by the time next assembly session happens, all these things are resolved. After me, Chairman BDA will be talking. I request you that any of you, because we have been having a one-way conversation, there may be little doubts. If you have something to ask Chairman BDA or me, if we are ready with the answer, we'll try to come back to you. If we are not comfortable ourselves, I promise you please give it to us. By tomorrow, before the sun sets, we'll come back to you with all the right answers, solutions, and the time frame. Thank you very much for calling me here. I'm sorry I came a little late. I missed Chairman Law Commission's address. Thanks for calling and all the best. Have a great evening. Thank you very much.
Absolutely amazing. Ladies and gentlemen, can I hear a big round of applause? Thank you for your commitment, sir. All right, ladies and gentlemen, before we move on to the next speaker, people sitting behind, you don't need an occupancy certificate to occupy the front rows. It's free. Please grab your seat because we have a very, very interesting personality coming up next. Ladies and gentlemen, it is my privilege to introduce Shri N.A. Harris, four-term member of the Karnataka Legislative Assembly, representing the Shantinagar constituency and the chairman of the Bengaluru Development Authority, BDA. A respected public representative and administrator, Sri Haris has earned recognition for his commitment to public service and urban development, having previously served as the chairman of the Bengaluru Metropolitan Transport Corporation, BMTC. He has played a significant role in shaping Bengaluru's growth and infrastructure. Today, as chairman of the BDA, he is at the forefront of urban planning, housing development and initiatives that directly impact residential communities and the quality of life of the citizens of Bengaluru. His insights on urban governance, infrastructure, and future of our cities make him a valued presence at Proprietas 2026. Ladies and gentlemen, put your hands together. Please join me in extending a warm welcome to Sri N.A. Haris. Welcome, sir. Ladies and gentlemen, how many of you think he's looking dashing in whatever he's wearing? Yeah, come on. Yeah, put your hands together for him.
Thank you, thank you. Good evening to everyone here. I know you're all tired of listening to everybody. You've got more than what is needed actually now, I think. On the dais, we have 𝗃𝗃𝗀𝗃𝗁𝗃, the chairman for RERA, and Advocate 𝗃𝗵𝗃𝗃𝗀𝗃, who is responsible for getting me here. And we have Mr. Ramesh and Satish Malleya, Rafiq Moideen, a lot of friends, a lot of developers, builders, apartment owners, and we are all in Shantinagar constituency. So I'm happy for that. As far as the issues concerned and the subject where it is going to is urbanization and coexistence. This is the main subject. Coexistence, nobody wants to agree. Urbanization, we don't know what is urbanization. That is where the issue is starting with. If we can understand urbanization, then the subject has not much of problem. Apartment is like a village panchayat in urban. Compared to a panchayat, village panchayat, is what exactly is an apartment in urban. Because that starts from there, the basic your problem is coming there. How do you manage your apartment? How do you manage your waste? How do you manage your water? How do you manage your electricity? How's the legal documents? You are ownership of an apartment, but you are collectively owning the building. These two things, if we understand, majority of the issue is over. Because the land belongs to whom, building belongs to who, sky belongs to who is the biggest question we face everywhere. And we dispute with that. If we understand we are part of that whole property and we have to live together, we need to exist together, coexistence, our issues can be resolved easily. As the chairman of Bangalore Development Authority, we are trying our level best. Now we are also looking at, the government also is looking at vertical growth for Bangalore city. Enough, we have gone all around. We have reached some 800 and odd square kilometers of development in the city. Now, I think even our Chief Minister 𝗃𝗃𝗀𝗃𝗀𝗃 also is of the opinion that more vertical development should come. We have some constraint in Bangalore city, the airport, HAL airport, Jakur airport, now the 𝗃𝗵𝗀𝗃𝗀 airport does not allow us to go vertically. We are just talking to them to resolve that even. So, I understand. If vertically it goes, you can take, if you just think about my constituency, Shantinagar constituency, we are just changing drinking water line, drinking fresh water, Kaveri. We are doing almost 380 kilometers of line in my constituency. You will reach from here to Mangalore, 380 kilometers means. That is the length of road and pipeline in one small constituency where the voters are 250,000. Population could be 4 to 5 lakh or maybe 4. So you can imagine how it is. So blame game is best. I will blame you, you will blame me, and there is nothing happening beyond that. No, that is not what we need. We need to resolve issues. The creator of problem is you, not me. You create problem and then you ask me to resolve it. It's highly impossible. If you don't create problem, then the resolution doesn't come there. So my request here is, if you people, as a developer, as a apartment owner, and you have now already a lot of associations, apartment owners associations, and a lot of things you have formed. If you all can work together, I'm sure life can be much more better and we can live happily. Some people they don't want to understand the problem is not there. So they keep on telling the problem. There's a saying, if somebody is sleeping, we can wake him up. If somebody pretends to be sleeping, you can never wake him up. Nidre ಮಾಡೋನ್ನ ಎಬ್ಬರಿಸಬಹುದು. ನಿದ್ರೆ ಮಾಡೋ ಥರ ಯಾರಾದರೂ ಆ್ಯಕ್ಟಿಂಗ್ ಮಾಡ್ತಾ ಇದ್ರೆ ಅವನನ್ನು ಎಬ್ಸೋಕ್ಕಾಗುತ್ತಾ? ಖಂಡಿತವಾಗಿ ಆಗಲ್ಲ. ಸೊ ದ ಇಶ್ಯೂ ಇಸ್ ಎಲ್ಲಿದೆ ಅಂದರೆ, ನಾವು ಇದನ್ನು ಅರ್ಥ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ರೆ ಸಮಸ್ಯೆ ಇಲ್ಲ. So now I don't want to make any commitment. I don't want to make a long lecture here. I know you have heard a lot of lectures. Rakesh Singh Sahab also told whatever is needed can be done. We will get it done. The government is in your favor. Let's understand. I am standing here to take some questions from you. If you have any doubts, you can ask me. I can answer you. That would be better than me talking about things to you. Okay? Yeah. Yes. Give a mic to few questions only, not many questions. Don't repeat it, just. And Beena, as an advocate, is trying to resolve a problem where she loses her business.
Ask him, ma'am. Check, yes.
And I don't understand why she is trying to resolve this when if there is an issue, she gets business. No, I mean, I'm just trying to put it, see. So, people's commitment is very important. You have a commitment to resolve the issue is more important. It's not, if I'm standing here today, for me, it is better for me to resolve this issue than to have a problem. My constituency, I have an association of all apartments. We meet regularly and we take their issues and we resolve it. So, if once it is resolved, there is no problem then.
That is so amazing of you to be so proactive, sir. So we go live Q&A. This is exciting, ma'am. If you have any questions, somebody, raise your hands. I'll come to you with the mic. My first question to you, ma'am.
Just to introduce yourself and...
Sure. I am Kavita Ranjan. I represent Almond Tree Row Houses and Villaments, Yelahanka, as the management committee in the capacity of a president. So thank you, sir. Thank you, Harris, sir. Thank you, Rakesh, sir, for your time, effort, and energy and coming here and listening to our vows. But at the same time, no offense to both of you, I definitely beg to differ when you say that thing is not as complicated as it seems to you. But they are trivial issues where, as apartment owners, as management committee, we get penalized and we get punitive actions, whereas simple people, those who are not paying maintenance, get away with things like calling the police for not allowing Zomato, Swiggy, small things. I mean, these are the issues that really need to be addressed. When a villament like us, 50 units only, out of which, if there are 10 defaulters, how do you think we run the society? How do you think we run the essentials? We run the entire show, WTP, STP. On top of that, every clearance certificate when we go for is asked for a bribe. How do we stop all that? These are the issues the common men, the middle class we face, and not about land reforms. Thank you so much.
I'll answer her.
Yes.
Thank you. I mean, it was a good question. Corruption is a major problem. Not apartment problem is a small problem compared to corruption problem. So that has to be handled in a different way. But apartment issue is like, you just said it, some of the people don't pay for the maintenance of the apartment, they don't come. But then when the apartment is being built and when the developer is there and when you are, before you buy the apartment, you should understand to get that point cleared. who will pay, who will be responsible, how the money will be collected, how the developer will transfer the apartment to association. That has to be made clear. When we are buying, we only talk about discount and take discounted rate, take the apartment, after that you get all the problems. Now, these things, I think as our brigade is here, so I'm also associated with brigade group, so I know what it is. If the developer and the apartment owners make a mutual understanding, where everyone, now see, government has a tax. You pay, you don't pay. Every year interest will go on, and at the end of the day, government will take auction your property. Maybe same way, even the associations also should form, and it is mandatory that you pay the maintenance. So as I think Gopalan was telling, if you have kept it empty, you are not using, what to do? Okay, you may put a condition to that. Maybe there's a small discount given when you are not in use or when it is in use, and everybody has to pay. Now, more than this, there are some issues like dogs. Some people love dogs, they keep feeding the dogs. Some people don't love dogs, they have a problem with that, it bites their children or their parents. Now, some fellow says, no, I want that, I will feed. So I tell, I'm very open, see, you love animals, you love, but first you love human beings, then you love animals. The issue is, now, who will be first? You will ask me that question next. So it's very difficult. These are all issues which we need to, that's why I said, the two major issues is coexistence and urbanization. These two, if we understand, the major issue is over. I think, madam, your association should make it in such a way that all these things, because you have to put it on document and make everybody agree to it, then your problems are solved. And certificates and other things, Rakesh Singh is sitting there, I am here. You have anywhere corruption problem, you can approach us, we'll get it done for you. This is a commitment. Sir, Rakesh Singh Saab, I have given a commitment. I said there anywhere they have a problem with certificate, they can approach you or me, we will get it done. Ek mic dena, Rakesh.
Yes. I really love the way this is going here, Mr. Rakesh. This is yours.
My immediate reaction to the two aspects of your question. One, the corruption, that is separate. Two, what you said about somebody not paying the maintenance. So what I checked, a system can be evolved where there's a competent authority who decides these kind of situations and give you a quick solution. I'll not promise because I'm not government, but what you are saying makes a lot of sense. I'll certainly convince. He's a very powerful officer in the government. Now he's again chairman. Sir, you help them, just take a phone and tell those people to give when they want some certificate, that's all. No, see, some people, some association, they take money from the owners and they don't do the work. So that is another issue. Some are that they don't get the things done at the government level. These two things. Some associations also take it granted to collect money from the residents. See, if I know I am practically, I own apartment, I develop, so I know what is the issue. So these are all different issues which I think they can resolve that themselves. I promise that within this week, that is by Sunday, I'll articulate what you have said. I'll request Mr. Malya, by next week we'll make it to government, and before end of June, I'll try that some kind of a structure should come up where these kind of issues, what Madam exactly raised, and any other related issue can be implemented, enforced in a particular time frame, because here the time is very important, sir. How will they run the association if maintenance is not properly created? I'll try to get it done. Thank you. Please don't repeat the question if anybody has any other question.
Wow, ladies and gentlemen, that's a commitment made in front of you because you asked the question. Can I hear a big round of applause for both the gentlemen? And I think Mr. Ramesh also addressed that question of people not paying the association dues, right?
Reputed builders selling flats based on RERA approval. We as owners trust that stamp of approval and buy our flats. But still, many builders sell their flats without a completion certificate in terms of the lift certification, electrical certification, effluent treatment plant, so on and so forth. Now, if we as owners know that something is under construction and we buy it without CC or OC, then what happens is it's like a deformed child born. The residents cannot do with a deformed or handicapped child which is born, because neither we have the money nor the wherewithal. And the builder escapes from the situation saying either he has gone bankrupt and so on and so forth. Does the law help us to reduce the gap between the law on one side and enforcement on the other side? We have to reduce this gap.
Please, please. Hello. Give one mic here, no?
Yes. Yes, I'm giving the mic.
Sorry, I asked her that I'll answer because I'm strictly on this issue for last so many months. I feel I have a solution, but somehow I have not been able to convince people. In Karnataka, the definition of occupancy certificate is different in different acts at different times. In RERA Act, the original Government of India Act, the definition of completion certificate, completion and OC is available. In Karnataka, the planning authority gives occupancy certificate, which I understand that occupancy certificate means that the project is or the building is completed as per the sanctioned plan, meaning thereby that structurally the towers are completed. On that, the planning authority gives completion. I'll seek your indulgence. And the builder says that now I have OC, my responsibility is over, it stops. Wherein the RERA Act or the RERA goes little beyond. It says that what you have promised to the home buyer in the form of assurance in agreement to sell and the brochure, unless you complete that, the project is not complete. So there has to be something like closure policy that the OC has been given by the planning authority, that building is okay. On that basis, they will get permanent power supply, permanent water. They can give virtual handing over to the allottees for doing their interiors and all. But the project is not completed. So the builder's argument that with OC the project is completed, in my personal opinion, is not correct. The project is completed with the closure, which means what all you have promised to the buyer as per the agreement of sale and brochure. Once that happens, then the project is complete. This is my understanding, and I feel that my understanding is not wrong. So it's already...
The gentleman was asking to gap to be reduced. That is exactly why RERA is made by government, where we are trying to protect every investor who is buying a house. So, see, the problem is not with RERA or with the government. Problem is with you. You are buying from a developer. You need to check who is the developer, how good is he has completed. You just buy from anybody and then you get caught to these situations. If we have some of the well-known builders in our city who give best of the projects. I mean, some of the builders have got awards for their projects. So all projects are all not on the same line. So you need also to decide from where to pick up the apartment and buy it. And legally, paper should be correct. What are you taking? As Rakesh Singh Saab said, completion is one part. What is the commitment by builder? That is that fulfilled, is to be checked before you give your final payment and you take position. That's your responsibility. Government cannot do anything about it. We did RERA so that the fund is not taken away somewhere else and the public is not cheated. So this is another issue where you need to do a little more hard work on that. Government cannot do anything about these things.
Could I answer, or is there any gap left?
As owners, we are not competent to check whether electrical connections in the building is okay. We are not competent to check whether effluent treatment is planned. We are not competent to check whether lifts are okay. So why can't there be something to give that closure policy, what you said?
That's what I said. That as when presently...
Sir, before you answer that, I think somebody had a question regarding fire as well. You wanted to ask almost the same question. What was yours?
Yeah, hi. Mr. Harris, very nice to hear you and all of that, and Mr. Rakesh as well. So I'm part of an apartment here on Lavelle Road, and we have a lot of senior citizens. The apartment is very old. Structurally, it's very weak. It's almost 30 years old, and we're trying to go for redevelopment, but we've approached Prestige and Brigade and all of them, so they're saying that we cannot do high-rise because, we don't have that width. The entrance to the apartment, the width is less than 12 meters. So I'm wondering if with the new law that is coming up, whether we'll be able to get the fire permission. We've met with the Deputy General of Police as well, and also the fire department, but they're saying that this rule is very strict with the, NBC, the new building code. 12 meters is required, so they're not allowing.
So the law says you get high-rise when your approach road is wider. So there's a limitations to what height we can give, because when you make a high-rise, so many more apartments, so many more vehicles coming in. As it is, Bangalore traffic block is there. So we give somebody, then that road width should be allowing more vehicle to come in. So that is a rule which is there, and it is in favor of you. It is not in favor of government. It is in favor of public. So if we all have to follow it, we can live more happily. I just stay, if I walk, it takes 8 minutes to reach my house. I took 30 minutes to reach here. That's it. So we need to understand how it is.
Mr. Rakesh, yes.
To answer you, that is what I was saying. We are trying to, not trying, RERA has already completed the work. We are trying to bring that closure policy which goes beyond OC, and it addresses all the aspects of lift, permanent power supply, water supply, if it is not from BWSSB, what is the situation, and all the amenities that has been promised in the agreement to sell and the brochure. Whatever is put in the brochure should be delivered. Excuse me, sir. What you said, if on a piece of paper, you can give the location of your property, number of units and area at a personal, before I leave. This is in my constituency, sir. I know that issue. At a personal level, what they... No, the road with entrance is small. No, then the I'm just like that I'm answering. Now the number of units is X. The total coverage is N square meters. Now those number of units have to be fitted. As per the BDA or the BBMP regulations of road width and fire safety, what best can be done, we'll try to give you a solution. Now, some of the top builders are involved in that property. They are backing out because the FSA is not permitting. मुझे मालूम नहीं, उसमें opportunity नहीं है, road नहीं है ना, approach नहीं तो आप और हम नहीं दे सकते. It's a practical problem. So I think we'll close. Questions will keep coming otherwise.
Correct.
Last one question and we'll close.
I will go with the lady out here.
Please take an important subject. That's the last one.
I would like to address garbage collection, which is a major problem in our Wadhur Road. I'm the president of the Prestige Greenwood Apartments on Wadhur Road. Now, over a period of time, we have from the by-lanes, people taking their garbage and bringing it and dumping it in front of our apartment. We as an apartment have recycling. We have managed our garbage collection inside, and we have kept a cleanliness over the footpath, everything. But the people from the village in the 𝗪𝗪𝗪𝗪, they come out and dump it on our thing. So every morning my job is take a photograph of that, send it to the supervisor and say, please collect the garbage. And then what happens is there is a holiday, there is no collection. The truck broke down, there's no collection. The driver is sick, no collection. The driver, somebody's died, no collection. So my problem here is, when will Bangalore have a more effective garbage collection?
Now the government is already on the job. We are trying to get a new policy on garbage and new tender is being called. the old contractors have gone to the court and taken a stay on that. The government, our Chief Minister, who was Deputy Chief Minister till now and in charge Bangalore City, has been put lot of effort to resolve this. So the court has intervened. The earlier contractors gone and taken a stay. We have recently, just maybe 10 days back, we had a meeting and we are trying to resolve that. I'm sure I understand your problem. We are at it. We'll try to resolve that issue, madam. Okay. Thank you.
Thank you.
So I think questions will be there. Last question. If it is an important one. Yeah. Okay. One last question.
Guys, it has to revolve around housing. A very pressing issue. Somebody has something pressing, not just a general query. You have a problem, it's very, very pressing. You came only for this. You came only for this? Okay. But guys, before I do that, I think we should encourage Shri N.A. Harris and Mr. Rakesh. They've been bold enough to come and commit certain things. It's very rare to see that.
Thank you very much. I have a question. In a larger project of about more than 30 acres, where the construction happens on the different phases, so RERA is getting allocated on tower-wise. Suppose in a larger project size, when they have 10 towers, RERA keep happens for 10 towers differently. Is there any protocols for RERA to check whether these guys have completed the previous project at the committed timelines and committed specifications? Because we have been observing that RERA is getting sanctioned for new buildings without checking whether they have completed the previous towers. So just wanted to understand on this. Thank you.
Presently, the RERA Act doesn't answer this question. What you are asking, that the track record of the builder, when his one project is already delayed or lapsed, his next project either should not be registered. Is my understanding correct? No, it is one project. In one project. You have it is under you. It is one project. He is talking about different towers. So he has taken RERA registration for 2 towers. It will be a master plan sanction for the entire area. Sir, sanction is one for entire 10, for one project, 10 towers. Okay. No, one RERA approval. No, it can't be 10 different RERA. See, 1 minute. Sir, can I intervene? Phase development you are saying. But so, plan will be one. One master plan. No, so what they do, for example, they have the total project of 10 towers. They took RERA approval initially for 2 towers. Right? They did not complete those 2 towers in the given time frame, and they again went to RERA and for proposal for 2 additional towers. You are very right. Each as on today, each registration or each project, because this 2 tower becomes one project, because it's called phase development. So this becomes one project. When we sanction the second project, that is Tower 3 and Tower 4, we don't take into, as on today, we don't take into consideration the progress of Tower 1 and 2. Because the delay of Tower 1 and 2 is to be handled separately. There is a separate protocol how the delay has to be handled. But for that purpose, the present Act does not debar the promoter to get fresh sanction for Tower 3, 4 once, second time, Tower 5 and 6, another time. That we don't have. It's a master plan sanction, and the RERA's condition limits to whatever thing they take permission. This not be done unless he has effectively done that. Completed the first project.
should come. We have to understand, sometimes we need to do, see, government is doing its best to clear all these things. As she rightly said, one day the auto won't come, one day the driver won't be there, one day the sweeper won't be there. See, these are all not anything which is not happening, it's there every day. I know in my constituency, I also face all these issues. But the best way is we all need to get together. Now, as an association of Bangalore Apartment Owners Association, Federation, I thank you for giving this opportunity to me and Mr. 𝗪𝗪. As a government, we are always open and ready to work for you. We are there to take your suggestions and try to make it better for everyone. Thank you. Jai Hind, Jai Karnataka.
Wow, give them a big round of applause, ladies and gentlemen. My apologies, I could not make everybody ask the question, just not practical. But coming to Shri N.A. Harris and Shri Rakesh Singh, they could have just come out here, given you a lecture and walked out. But they stood out here and they answered your question. If I were you, I would stand up and clap for them. We need more proactive leaders. Can we all give them a standing ovation? We need leaders who are accountable, who would answer to you, who would say, ask me, tell me your problems. Give a big, big, big round of applause. Ladies and gentlemen, thank you so much. Thank you for being kind. Please remain seated. Now comes one of the most important discourses, one of the most important keynotes of today. By the way, some of you who could not ask questions, you could always consult Advocate 𝗵𝗂𝗶𝗀𝗍's office and NLS Legal Aid Society. You could email us. We'll make sure your queries go to the right department. On that note, ladies and gentlemen, a bunch of keys was misplaced on the table outside. If they happen to have money inside the locker, give the keys to me or go and collect it. Once again, somebody lost keys, collect it outside. Ladies and gentlemen, let's move on. It is my distinct honor to introduce our keynote speaker for Proprietas 2026, Advocate 𝗵𝗂𝗶𝗀𝗍. Yes, ladies and gentlemen, she deserves your respect. With over 27 years of experience in the legal profession, Advocate 𝗵𝗂𝗶𝗀𝗍 is widely recognized as one of Karnataka's leading experts in real estate and apartment law. As the founder of Next Legal Services and NLS Legal Aid Society, she successfully represented numerous apartment owners associations, homeowners, and developers in complex legal and regulatory matters. Known for her expertise in apartment governance, associate formation, the Karnataka Apartment Ownership Act, and the real estate dispute resolution, she's played a significant role in promoting legal awareness among apartment communities across the state. A champion of women's rights and access to justice, she is also the recipient of the Service Excellence in Apartment and Real Estate Law Award, the Times Power Women Conclave and Awards 2026. Ladies and gentlemen, please join me in extending a warm welcome to our keynote speaker, Advocate 𝗵𝗂𝗶𝗀𝗍. Let's get a big round of applause. Welcome, Beena.
Thank you so much, Shabir. Good evening to all. Good evening, Sri N.A. Harris. Good evening to Mr. Rakesh Singh, the RERA chairman, Satish Mallya, my dear friend 𝗪𝗪𝗻𝗁, and good evening to you all. Thank you so much for coming here. The term proprietas, you know the meaning of proprietas? Know your property. You have to have some basic understanding about the apartment law. That is the reason we have started this initiative. 2 years ago, we had Proprietas number 1, in which we have covered the apartment owner's rights and a lot of things, obligations of the builder. Probably some of, you might have appeared for that. Now, there is a serious issue which is going on in the apartment. In the sense, as our RERA chairman has mentioned, once the project is completed, there is a huge vacuum, according to me. We have real regulations till that time. We have RERA regulations, we have planning authorities rules, we have BDA rules, we have a lot of things. But after the completion of the project, what happens? The builders, to whom the builder has to hand over the project. As Madam has pointed out, many people are not paying the maintenance. What should we do? I have a client, in that it's a joint development agreement, where the developers share around 100 units are there. Builder has completed the project, occupancy is done, builder has also formed an association. But this 100 units, he kept it in his hand and he is not ready to pay the maintenance. What can we do? These kinds of issues are there in every apartment. So, because I know that this is a very boring subject, a small example I want to show, and on that basis I wanted to explain everything related to apartment law. The snake in the parking lot. See, a big cobra. It was there in the parking lot. It was hidden in unused, materials which was dumped in the parking lot. Can you show that slide? The second slide which is showing. Yes. This car parking area, the owner has dumped all these materials. A snake took shelter under that. A resident died. Who is responsible for that? Can you tell me who is responsible? Resident only? Builder has moved out of the property. You cannot blame the builder. Then, association is also there. Why? Association is the custodian of the property. Custodian in the sense they have an obligation to maintain and manage the property. So if the association is not maintaining the property, a kind of liability, we can call it as either vicarious liability or some other tortious liability, like, we can sue the builder the association against the civil negligence as well as criminal negligence. Here a person died. So both these are there. So what I am trying to say in the sense, this program we are focusing about the association governance, association formation. The million-dollar question here is under which statute we have to form an association, even though we have a specific statute, that is Karnataka Apartment Ownership Act. There are many societies which is formed under the Societies Registration Act. Okay. Under the Societies Registration Act, and there are many societies under the Karnataka Cooperative Societies Act. The objectives of these two, just carefully listen to these points. The objectives of these two statutes are totally different. Every statute has an objective clause. PF, for example, PF Act, it has an objective clause. It is meant for Provident Fund. Companies Act, it is dealing with companies. Likewise, Societies Act, it deals with what? Charitable, scientific and literary societies. You cannot form an association for maintaining and managing a property under the Societies Registration Act. The court has cancelled many societies. Even then, unfortunately, the societies registrar continued to register the societies. Now, there is a direction to the societies registrar, a collective direction not to register any apartment owners association under the Societies Registration Act. You can form an NGO under that. Okay. Then the second one is what? Cooperative Societies Act. I'll stop for a moment. Oh, okay, sorry. The second one is the Cooperative Societies Act. You know that the objective of cooperative society is to promote the cooperative movement in this country. Your property is a private property. You are paying money to the builder. The builder, whoever it is, now Brigade is here, I can give an example. You are paying directly the money to the builder. There is no subsidy from the government, you are paying tax and you are paying a lot of things, right? So purely it is a private property, there is no need of bringing any cooperative societies, because the purpose behind the cooperative society is to promote this cooperative movement as well as a public purpose. In a private property, there is no need of bringing any cooperative society. I have seen many cooperative societies bylaw. There is an objective clause in that bylaw which says that the property in the sense the project, the entire project land has to be conveyed in favor of the society. Then who you will be? Your property is transferring to a cooperative society. This cooperative society has a special entity. It is considered as a separate person sitting next to you. So if you transfer your property to the cooperative society, what will happen? Your right over the property will be gone, and the cooperative society will become the owner of your property. There was a direction to one of the project builder to transfer the project land to the cooperative society. Then the builder said, I will cancel the sale deeds, whatever I have executed in favor of my apartment owners, because I cannot simultaneously convey the property or the project to same persons. I mean, parallelly to two different entities. One is to an individual and the other one is to a cooperative society. So these kinds of issues are happening here. The code has clearly mentioned that in an apartment, you have to form an association under the Karnataka Apartment Ownership Act. If you are very much interested, I can give you the citation also, Writ Appeal 564/2024. In a residential apartment, you have to form an association under the Karnataka Apartment Ownership Act because it is a specific statute dealing with your property. In the Cooperative Societies Act or in the Societies Act, you cannot find out any clauses, any provisions dealing with the property. This is one point which I wanted to tell. And the second point is related to UDS. There is a misconception going on here. The project land has to be conveyed to the association. You are getting UDS along with the unit. You are not only getting a building or an apartment unit because it is constructed on the land, it is not on air. So the builder will be giving you a small piece of land proportionate to what? The built-up area which you are entitled. So you are getting the apartment unit along with the piece of land. That piece of land is the undivided share. So there is not even an inch left after the project is completed for the developer to convey to any other person or convey to any other association. So please don't approach the court or to RERA or wherever it is saying that my project land is still with the landowner or with the builder. It has to be transferred to the association. It is a misconception. Your land is with you. That land is given to you by the builder in small pieces. It is known as UDS. The difference between an independent property and that piece of land is that it cannot be divided. Because, as I'm just borrowing from Mr. N.A. Harris, it is a collective unit which everyone is jointly owning, right? So that concept we have to see. The second Proprietas I thought of, calling with this particular important issue. Everyone is coming and saying that my land is not conveyed, my land is not given to the association after having a sale deed in their hand. If you just check it in your sale deed, last page there is a schedule of the property. The first schedule will be Schedule A. Schedule A contains the entire project land. Schedule B is your undivided share, probably in percentage wise or square feet basis. And Schedule C is your apartment. So this is one thing which I want to tell you. Please don't do that. Don't convey any of your project land to cooperative societies or any other societies. We have a specific statute, that is Karnataka Apartment Ownership Act. Please go ahead with forming an association under Karnataka Apartment Ownership Act. In the Google form, we have also asked people to send some queries. The most of the queries we have received related to Apartment Owners Association. As he has pointed out, if you have a proper association with a proper bylaw, bylaw is the constitution, that is the main document where it prescribes the rules and regulations of that particular apartment complex. You have to follow that. There is absolutely nothing, ambiguous here. Bylaw says that, you have to keep a CCTV, keep a CCTV. In case if the bylaw says and you don't have a CCTV, what happens? If any theft happens, then the association will be responsible. The snake example, we can go back to that example. In that example, as I said, if the resident died by getting a snake bite, the association is responsible. If someone is drowned in a swimming pool, vicariously it will come back. Because of the negligence of the association, if anything happens, they will be responsible. There are fire and safety equipment. If it is sold, who will be responsible? Finally, the responsibility comes back to the association. So how the associations can overcome all these things? They can be vigilant. They have to follow certain things. They have to ensure that systems are working proper. If any financial issue is there, who will be responsible ultimately? The Apartment Owners Association. How to overcome that? You have to have a system for proper auditing. And if you have done all these things and any mishap happened, the presumption is that it is not yours. It is the act of God. You are safe. In one of my clients' apartment, the lift fell down. There is a rope or something which is connecting the lift, right? So that one is broken. The person is crushed inside the lift and he is paralyzed. Who is responsible? The police came and registered FIR against the apartment owners. Fortunately, they have a proper association. They have formed under the Karnataka Apartment Ownership Act 1972. Just imagine if it is a society, then your association is also not legal. Then what happens? Every individuals who is inside that committee, they will be personally liable for this. So be conscious about all these things. And you have to have a proper body for maintaining and managing the association. Just custody of the property, when you take it, there are a lot of responsibilities are coming to you that the association has to understand. Otherwise, the civil negligence as well as criminal negligence will pop up. See, this vacuum I said, right, project completion, we have regulations. After the project completion, what happens? We have only one specific statute which says that you can form an association. And according to me, many people are saying that the Karnataka Apartment Ownership Act is not a good act, or I mean, there are loopholes or something. But I don't agree with that. It's a 50-year-old act. One competent authority is not appointed by the government. That doesn't mean that the act is weak. According to me, competent authority is not required. If a competent authority is there, your job will be double. First, you have to go to them. Then only you can come back to court. So if you directly go to High Court will say that no, there are certain alternative mechanism. Why can't you go there? Then come back. They will take another 2 years. So these will be delayed. Then one other problems which people are pointing out, that there is no registration certificate. Do you have a registration certificate when you purchase the property? Do you have a registration certificate which says that you are the owner of apartment number 101? How will you find out that? Your sale deed, on the back side, there is an endorsement from the registrar. It says that this particular property is registered in your name. That number you will be using as what? Your registration number of the property. Likewise, under the Karnataka Apartment Ownership Act, there is a document called Deed of Declaration. Since it is connected to the property, the makers of statute, according to me, very carefully thought about this and made it as a mandatory document to be registered before the sub-registrar, the property registrar. And this deed of declaration is a collective document stating about the property, the entire project. Your sale deed is only talking about what? Your property. But this deed of declaration is describing about the entire project. So you can take it as a reference point, right? And the Karnataka Apartment Ownership Act, there are provisions for bylaw. Bylaw, how to draft a bylaw? What are the provisions to be included in the bylaw? What is proxy? What is quorum? People are coming and asking questions, even in the Google form also a lot of things are there. But you know, the statute is very clear. Section 16, if you read it, you can understand that. How to draft a bylaw? Probably a little weaker one. You can strengthen it. A format is also being given. So, statutes are there. People are not utilizing it. They are just going ahead with something else without having basic knowledge about the property. The property is the one which you are investing more, right? It is the biggest investment in your life. For an apartment, you will be investing around 2 crore, 3 crore or whatever it is. And if you are not aware of the basic laws related to apartment or property, I think it is time for you to have a little knowledge. I'm not saying that the entire things you have to study, as he pointed out. I will be jobless. But the basic things at least. People are coming here by saying that, you know, the sale agreement is there. What is the need of sale deed? They are not understanding the difference between sale agreement and sale deed. What is UDS? What is occupancy certificate? What is the importance of occupancy certificate? What is khata? People are thinking that khata is the title document. It is not the title document. Your sale deed is your parent document. Okay, the sale deed says that you are the owner of the property. If there is any delay in that, then you have to be worried about that. Okay, so the general things, it is time for us to sit together and to understand it. We have learned a lot about sin theta, cos theta and all those things in schools. But unfortunately, you know, we didn't get a chance to learn constitution or the basic laws. I think it has to be considered by the government Okay. So these are some basic things. I don't want to, I know that this is a very boring subject. If you have any questions or anything, see, one point which I wanted to emphasize, I repeat it again, that your negligence, then the vicarious liability. Vicarious liability says that master is responsible for the servants thing. That is the usual word they are using it. It's an old concept. This vicarious liability, when it comes, you are an interesting facilitator or a security agency. And that security agency has certain responsibilities. He has a responsibility to pay the Minimum Wages Act. He has a responsibility to pay the PF. He has a responsibility to pay the ESI. And the Post Act, if more than, 10 female employees are there. All these are his responsibility. And in case if he is not doing this, who will be responsible? Association. Association means who? You all together are the association. This is another misconception. Association doesn't mean that the executive committee members. Association means you all together. Karnataka Apartment Ownership Act has very beautifully mentioned that. Association means all the apartment owners join together. And certain people taking responsibility on a particular time period is the executive committee. And this executive committee has to act on the basis of bylaw. Bylaw is a Bible where they can refer. If the bylaw has to be amended, the general body, you can call it. And the general body is the supreme body, not your executive committee. If the general body says no, you can't do anything. If the general body says yes, with majority, you can go ahead. Okay. So if any doubts or anything, we can, go ahead with that. Many people have sent in Google form. So from one apartment, they are asking BWSSB related issues. The BWSSB chairman has had agreed to come, but I think some reconstitution happened after the, that recently. So because of that, I think the chairman itself is changed. So he didn't come. I'm so sorry for that. We can coordinate with them again. So his doubt in the sense, they had already paid for the entire phase. Like someone has pointed out that, there are 10 towers and 2-3 towers were not completed. In this apartment also, these were the issue. 2-3 towers were not completed. Sorry, I think I can continue. I'm so sorry. I know that your time is very precious. Okay, I'm just explaining to them. Thank you, sir. So in this, what happened in the sense,
This session is in progress. It is considered to be very disrespectful. Kindly remain seated. Thank you so much. The session is in progress. Ma'am.
Okay. So now you got a very good interaction with Mr. N.A. Harris and the chairman of RERA. Even they have also promised that, they are ready to sit with you. Probably we can coordinate for, getting some answers from them directly without much introduction. I know that you will be very impatient. Then this particular issue, actually, there were, just imagine there are, as per the plan, 10 towers. When 7 towers were completed, then BWSSB connection is given. Then another 2 towers on progress. But the BW department came and disconnected by saying that the deposit towards the other two towers were not paid. So ultimately, the BWSSB department has removed the connection. They had made the payment to the builder. The builder has paid a portion of it. That's what I believe. See, this one important thing in the sense, these kind of connections, they need not have to pay it in advance. It will come in stage-wise. 30% initially, 60% initially. I mean, the second phase, like that. Probably the builder might have given the 2 installments, the next installments they might not have paid. In such situation, BWSSB or BESCOM or whoever it is, they will come and disconnect it. So here also, that is what happened. Now, water is the basic amenity. You know that we need water. So without water, now they are struggling. What should we do? They are depending on some commercial options. No water connection, can we address the issue? That is what they are asking. The only option in front of me is to approach the court. We have guided them. We will guide them. And one thing which you have to take it from this in the sense, the Karnataka Ownership Flats Regulation Act as well as RERA says that if you pay for BWSSB, the builder has to deposit this to an account which is created for BWSSB. He cannot utilize this fund for something else and come back by saying that you don't have this. So this is the only thing which you can take it from here. And the only option in front of us, this particular client, is to approach the court. Probably we can also coordinate with the BWSSB department and to get some solution for that. Yeah, is there any other queries? A lot of queries were there. All those things were connected with association formation, please. So I think almost I had also included. Please, sir.
Yes. She's pointed out to you. You could step forward, collect the mic from my hands, and you could ask your question.
Hi, ma'am. Good evening.
Good evening.
So, I am from 𝗀𝗵𝗂 Forest View. I am the Vice President of the Management Committee there. With all due respect to the KAOA Act, the one problem which we are facing is that a lot of residents are questioning the competency and authenticity of the KAOA Act. A lot of litigants, as per legal term, have come on to saying that, please show the registration certificate. Even if it's KAOA, is it the right competent authority? That's question number 1. They have approached the court, and as you rightly pointed out, if there are so many mechanisms in place already, then why is the court accepting the cases? We have so many acts which is actually in favor of the right resident or the correct behavioral resident, but then if you're following everything, then still there are cases on us. So I'm not able to understand if KAOA is the right act or not. If it is, then I can go back to my general body and say that, hey, our society is registered correctly. But I think we are facing a lot. I don't know if this problem is faced by others, but this is becoming a regular notion in our society at least. So I wanted to hear your thoughts on that.
This issue can be resolved by the government with a single notification. That is what I believe. They have enacted a statute. They are the one who has enacted. For every statute enactment, a lot of money is also required. Then, in the statute, it is very clearly mentioned that it is a specific beneficial statute for apartment. We don't have any other statute for apartments in Karnataka, at least I can say. So when you have a statute, that is what I said, that example of Provident Fund or company. You cannot go and register your company under some other act.
No, it's under KAOA only. Because
I'm just saying that. I'm just giving you an example. What is the difference between a specific statute and a general statute?
Right.
Specific statute is for that specific purposes which is mentioned in the act. What is the specific purpose mentioned in the act? The Act has provided a lot of things related to apartment maintenance, how to maintain the apartment, how to manage the apartment, how your bylaw should be drafted. Everything is mentioned in that Act. So people are not following it and they are thinking that the registration certificate is the biggest one. That is the reason I told you, do you have a registration certificate which says that your apartment is such and such?
Yes.
You don't have. Do you have that? This is my apartment's registration certificate. But your apartment is registered. What is the evidence of that? On the sale deed, if you check it on the back side, there is an endorsement from the registering authority with a number. So Section 60 of the Registration Act has mentioned that when the registration is complete, when this endorsement is given, the registration is complete. There is no need of a certificate. If I can give you one other example. Do you have a certificate saying that, what is your name?
Deepak.
Deepak. Do you have a certificate saying that your name is Deepak?
I do. I have a lot of certificates.
A lot of connected things are there. Birth certificate, what is the importance? Your birth date, not your name. Your passport, what's the importance?
Nationality.
Yes, you are the citizen of India or wherever it is. Now the Aadhaar card is a recognized identity, but you don't have a certificate which specifically says that I certify that this is Mr. Rakesh, etc. It is not there. So registration certificate is not the biggest thing. Whether it is registered or not.
It is.
Registration means endorsement by the registering authority. The Act has mentioned that who is the registering authority? It is the Property Registrar, Section 13. See, the Act has clearly mentioned all this. How to register, where to register, how to draft it. How many statutes are like that with a model bylaw also? But even then, there are certain, advocates of cooperative society. And I'm so sorry to say that we can see maximum corruption in cooperative societies. Am I right? Wherever you have taken. I'm from Kerala. This urban banks and, even in Karnataka, crores of. Because only 20 members are required for creating a cooperative society. Now there are huge townships. Just imagine 20 random members. They just created a cooperative society with an objective of saying that the project land has to be conveyed to them. What happens? The word convey is, the meaning of that sale. People are randomly using it. Convey, deemed conveyance, a lot of things. So that is what I'm saying. Once you get your sale deed in your favor, you are safe. You are the owner of that property. The next thing is what? It's a collective ownership. For that we need someone for maintaining the property.
True.
Right? A karta or whatever we can call in the joint family. Just imagine, hypothetically I'm saying this karta is the committee. But in that family, we all should be a member, right? My property is also there, so I should also be a member.
Right.
Random 20 members cannot create a cooperative society and ask me to follow their rules and regulations, where there are no rules and regulations related to the properties.
But in reality, that's happening, ma'am. And the problem is that
I understood.
And the problem is we are not able to put punitive action because they have a high court order. So I know. I don't want to make it conversational, but the larger problem statement which I wanted to highlight is we have an act, it is enforced, it is registered, but still there are loopholes. And because of 20-25 individuals, 850 residents have to suffer. That's a larger point. I just wanted to land with you, and just a little bit on the lighter side. If you can have a lot of people in your team to visit societies and educate them, I think it will be doing wonders. Because people have to be educated on this to make an act. Because we have, sorry to use that word, a lot of unparliamentary people coming into apartment associations, and they pass a bylaw which eats up the society for years to come. That is the major problem. So I think the awareness training program to educate people, youngsters coming in, I'm happy to join the MC. I'm 30 years old. People should come in, volunteer, and it's not a thankless job. It's a commitment I'm making for 2 years. I want to live in that society and give my kid the best facilities that way. So I feel that should be the messaging that I think from your team should land. Thank you so much.
Definitely, yeah. Okay, so you can write your questions. Can we take a short break? They have some plans for that, so that We'll be taking it.
Ladies and gentlemen, we'll take a short break and we'll come back after the break for the Q&A.
I'll come back.
Thank you so much. A big round of applause. Advocate 𝗵𝗏 Pillai. Ladies and gentlemen, it is our honor, it is our privilege, and we'd like to acknowledge Mr. 𝗺𝗂𝗶𝗵 Ladies and gentlemen, he's the CEO, Residential Brigade Group. Give him a big round of applause. Thank you so much for being out here, for encouraging us, and for making this happen. He's a seasoned marketing and sales professional with a total of 37 years experience, out of which 29 years plus has been in the real estate in India, Mumbai, South India. Currently he's based in Bangalore with a real estate developer, which is of course Brigade, handling multi-domain sales, manages the entire spectrum of real estate marketing and CRM activity for them. Ladies and gentlemen, once again, give a big round of applause. He is adjudged as one of the top CMOs in the real estate sector, recognized by ET now. Thank you so much, sir. All right, ladies and gentlemen, very important announcement for people who are walking away. This is not over. Advocate 𝗵𝗏 Pillai will answer more of your questions. Meanwhile, we have a dance performance coming up by the students of St. Joseph's Law College. Let's have a cultural interlude. Give them a big round of applause. Thank you so much. Welcome them on stage. Ladies and gentlemen, Advocate 𝗵𝗂𝗶𝗍𝗍 Pillai is out here. Give her a big round of applause. She's been very kind enough. So, after the vote of thanks, you could meet her one-to-one You could sit on that sofa and you could ask that query. In the interest of time, ladies and gentlemen, it's time to conclude this event. And to deliver the vote of thanks, put your hands together, ladies and gentlemen, for Advocate Nidha from NLS Legal Aid Society. Give her a big round of applause. She'll be delivering the vote of thanks. Once again, if you have any questions, you could do a one-to-one. Check. People who are waiting to do one-to-one, let's wait for the vote of thanks. Post the vote of thanks. You could. I love the way you're all sitting around her like that. Thank you. Over to you, Nidha.
Good evening, everyone. As we have come to the close of an enlightening and enriching day, it is my privilege to propose the vote of thanks on behalf of the members of the NLS Legal Aid Society. I would like to begin by thanking all the distinguished guests for taking the time to be with us today. We extend our sincere appreciation to Justice Ashok B. Hinjagiri, Chairman, Law Commission Karnataka, and former Justice of the Karnataka High Court for sharing his insights. Our heartfelt thanks also goes to Sri Rakesh Singh, retired IAS, Chairman of Karnataka RERA, for providing their valuable insights. We are equally grateful to Sri N.A. Harris, Chairman of Bangalore Development Authority, for sharing his perspectives on urban development and housing. We also thank retired Judge K. Ramchandran for joining us and contributing to our discussions today. We would also like to thank Advocate 𝗵𝗵𝗍𝗂, whose expertise and practical guidance helps translate complex legal principles into knowledge that can be applied. A special word of appreciation to Sri Rajendra Kumar Kataria, IAS, for sharing his time, experience, and perspectives with us. I would also like to thank Sri Ramesh Padmanabhan, Governing Council, BAF, for his insights. My sincere thanks to our moderator, Mr. Shabir, and also the volunteers, organizing committee members, technical team, hospitality team, and every individual who worked diligently behind the scenes. Events such as this are made possible by the dedication of many people whose contributions are often seen or often remain unseen. I would also like to acknowledge our performers for their cultural presentation, for adding a special touch to the event. Our gratitude also extends to Sri Pauline Priya, the principal of St. Joseph's Law College, for hosting us, and also to Prime Events and Mr. Ranjit for their coordination, and to our technical team for ensuring the program proceeds smoothly. I would also like to thank press and media for joining us today and for helping carry these conversations beyond this venue. Most importantly, I would like to thank all our participants, apartment owners, apartment association members, lawyers, students, and members of the public. Your engagement and participation are what made Proprietas 2026 fruitful. As we leave today, I hope we carry forward not only the knowledge we have gained, but also a renewed commitment to responsible property ownership. Thank you once again for being a part of Proprietas 2026. I wish a pleasant evening and enjoyable dinner ahead. Thank you.
Thank you so much, Advocate Nidha. Ladies and gentlemen, I'd like to welcome back Advocate 𝗵𝗵𝗍𝗂 for her concluding remarks. Ladies and gentlemen, a big round of applause. Welcome her back.
See, before starting this question and answer session, I just wanted to say 2 words about SBM. You might have seen that SBM stall outside. It is an attempt of sexually abused survivors of that. My humble request to all of you, if there is an opportunity for you to buy anything from them, they are trying to, survive with sewing machines. Please do something for them, and we will share you their website in case if you are not able to buy something from here. Okay? And Brigade project is related to senior citizenship. If anyone is interested, please. Thank you so much. I'll come back to you. I want to sit with you and then we can discuss.
All right, lady.
Sorry. No, you can sit. No, it's okay. I can stand. Broadly, how many stages are there in obtaining OC? You don't have to go through compliance and other things. How many stages of approval and who is the corresponding approval authority if it is under BAYAPA and Panchayat, Gram Panchayat? They are not a Gram Panchayat.
Yeah, you're talking about the project approvals, right? Your doubt. Oh, okay. See, CC means, commencement certificate, right? Oh, you are referring completion certificate. See, the completion certificate is actually, no, completion certificate from whom you have obtained? Okay. See, commencement certificate is for at the time of commencing the project. I'll tell you, I'll come to that. There are 2-3 things which I wanted to explain. Commencement certificate, the developer has to obtain, after this columns, foundations and all those things. So it is ready for commencement. You can consider in that way. Then, after the commencement certificate, then the next one comes, what is that? Occupancy certificate after the project is completed. Without commencement certificate, the chances of getting an occupancy certificate is very less. You are talking about the planning authority. So you said the completion certificate is received. Now your problem is occupancy is not received. Occupancy, there is a lot of delay in all the project. I don't know whether I can say it loudly, because lot of money is required for getting an occupancy certificate. Many of the builders are not able to procure that. So probably, what I am thinking in the sense, like this we can also have a group discussion. I can try to invite government officials also in this. Unfortunately, because of the internal reconstitution of the ministry, as I said, BWSSP chairman, he changed yesterday. Those kind of things are happening here. So once at the right time, we can have a discussion. OC is a very important thing. Without OC, you may not be able to, obtain khata. Registration, the law says that without getting occupancy, as I said, no, what is the meaning of occupancy certificate? The project is safe to occupy. Project is ready to occupy. The project is safe to occupy. So the law says that you should not occupy a building without getting an occupancy certificate. But if I say that you should not go and occupy the building, you are the one only losing the money, right? EMI is there, then you will have to pay additionally rent somewhere else. Lot of things will be there. So the practical solution is you can possess the property. This is not the legal solution. A practical solution, you can possess the property, occupy the property. No, without occupancy certificate, it was possible, now it is not possible. You got clarity on this? Okay, fine, yeah. Please. Fine. No, this OC, I think DKS has also mentioned certain things yesterday related to OC and khata and regularization of the properties. Probably, we all have to go and meet him. Everyone has to, we gather together. This proprietors, what can do through proprietors, we will communicate to you. So these kind of sessions, if people goes together, they will also be interested. Like N.A. Harris has mentioned, RERA chairman. With RERA chairman, we can also have some discussions. With the different departments, we can also have certain, discussions. We have to create a group. That is what I wanted to say. Please, ma'am.
So my name is 𝗪𝗪𝗃𝗃. I am a social media manager of a lot of groups in Bangalore, and a lot of groups, Facebook, WhatsApp, and a lot of things. So it's like a lot of questions come around these, and I'm like surprised many don't even know the basic things. So I was going to in fact request you the same thing, like can we have some education sessions or some newsletter or some channels where people get to know, starting with basic, maybe probably then they can reach out to you for the queries further. But the basic education is something which is the need of the time, because this act has come in place and many even don't know. I mean, there are many with the society registration still with that act. So I guess you can probably, the group thing, please, I have sent you a message on your phone, and if you create a group, please add all of us.
Hello.
I'm also so interested to, be with you guys, and if I can do something for rectifying this, definitely I'll do that. Now you all have our details, right? You might have got it from the registration desk. Please communicate to us. I'll appoint someone, from my team itself.
Check.
They will coordinate with you. If you are not getting any answer from my team, please let me know. Okay? Okay, whatever it is.
Thank you
Sorry, he was asking for a long time. Yeah.
See, it's a long pending project, almost 18 years or over. 1,000 apartments are there, 10 blocks are there. 10 blocks. They are saying that, apex will be formed only after the third stage is completed. Phase-wise development is there.
Okay.
Correct. Apex is because for common area maintenance, it is DOD is there. That is one question, madam. One last, big.
Okay.
See, in the functioning of the association, what is happening is members are not coming forward, the owners. But according to Apartment Owners Act, I read that family members can be OBs. They have the voting rights. So these two questions we need some clarification, so that if the owners are away from the country, their family members can be allowed. That provision is there in Rule 9. Could you please elaborate?
See, we need not have to depend on the act for this. See, you can execute a power of attorney. Authorizing, that power of attorney, through the power of attorney, you can authorize a person, whatever you want to do. He can act in your shoes. They cannot reject. No one can reject, but it should be a registered power of attorney. Okay. See, whoever is purchasing a property, along with that, you can also execute a power of attorney. Again, I'll say that even though you are in your 30s, execute a will. That will also definitely help you. Because a lot of legal, in case if someone dies without executing a will, the headache is too much. I'll be getting work, but your headache is too much.
Correct. Just a second.
Madam, apex formation, sir.
1 second, just hear this. We all think it is great to execute a POA. Fantastic. Please check whether the person is an Indian citizen or he has got overseas citizenship. If a person has got overseas citizenship and his name is 𝗬𝗵𝗃𝗃, he cannot execute a power of attorney under an Indian law. He should get it apostilled and he should get it all sorted out at their end. Please be sure about that, because there should not later be a challenge that the power of attorney was not properly done. This is specifically in case of people who have taken other countries' citizenship. You can have a OCI card, but that doesn't mean that you are an Indian citizen now.
So the person who executes or the whom it is executed?
The person who gives the POA.
He should not be
If he's not of Indian citizen on that date, he has to execute it as per the laws of that country.
No, 1 second, let me clarify that. See, power of attorney means what? You are authorizing someone
to act on behalf of you. Okay, so if you are authorizing your blood relative, for example, who is blood relative, as per law, your siblings are blood relatives, your parents are blood relatives, your children are blood relatives. One exemption is given, your spouse. Okay, for selling the property, you have to register this power of attorney. Whoever it is, you have to register this power of attorney. But if, it is related to the immobile property. Immobile property means land, property and all those things. Movable property means your bank deposits and all. For dealing with immobile property, you have to register a power of attorney. In case, if you execute the power of attorney in favor of your blood relatives and your spouse, stamp duty will not be there. But if you register a power of attorney in favor of me, you have to pay stamp duty. If your value of the property is 3 crore, then approximately around 5%, 3 into 5%, how much? Around 15 lakh rupees you will have to spend for that. So that is the reason it is always better to register the power of attorney in favor of your blood relative. Coming to his point of apostilling the document, the law behind that particular point is, if you are executing a document outside the country, it has to be authenticated. If you are executing a document from India, it is not required. But registration is an exemption related to immobile property. But anything related to, for example, a name change, if you are executing a power of attorney from US, you have to go to apostille agencies or embassies. Embassy attestation is too difficult for you. There are agencies, because India and US and all are a part of Hague Convention. There is a convention. Based on that, you can go to certain agencies. These agencies are known as apostille agencies, APOSTILLE. So there you have to go and get it attested. Then once the document comes here, if it is related to sale of your property, then this document you have to take to the district registrar office. There it has to be again authenticated. So 2 steps is required. Okay, but what my point, his question is related to, can he appoint someone to act on behalf of him? He is the owner of the property. So execute a power of attorney. Family unit, because honor means, you have also shown me. What is the definition here?
Includes a person.
Person includes a joint family. Okay. His point. So on a safer side, sir, my suggestion, you have to fight among your people itself. Tomorrow if any problem comes, I won't come there. If you have some cardiac issues or something, you have to call your neighbor. So my suggestion always is to don't go with argument. As you pointed out, it is correct. But it's always better to have a power of attorney in your hand and then show to him. It's not a big thing. That is one. When it comes to your Apex Federation, okay. Yeah. So there are 3 association, 3 deed of declaration I understood, right? At least 3 phases. In that, every deed of declaration, the law says that bylaw should also be attached. Right? Deed of declaration is not a single document. It is annexed with bylaw. And I have pointed out earlier, it is your Bible or Gita or whatever you wanted to call. So, bylaw says what exactly the rules and regulations, how to maintain and manage the property. Okay, so this...
If the deed of declaration is not executed by the builder, What can be done for that if the deed of declaration?
That's a very complicated thing. So in your case, actually, builder is ready for all these things. Only thing is that an apex federation is not created, right? It's better you can talk to the builder, ask the builder to create an apex federations bylaw. Apex federation, because there are 3 associations, A, B, C association. Huh? Okay, 3 or 10. There are, just imagine 3 associations or 6 associations. A plus B plus C plus D plus E is the apex federation. And this apex federation is controlling wherever it is required. So in your bylaw, there should be clarity. You should not give a lot of authority to apex federation also, because your apartment complex needs might be different. And this apex federations, what exactly they have to do? Probably the roads and common area maintenance, management, and a lot of things. So why the builder is not agreeing?
After the third phase is over, I told. Third phase is not yet started also.
See, big, huge apartment townships, there are practical difficulties, I do agree. But, you know, we can talk to, I mean, we can. If the builder doesn't agree, then we can send a letter to the builder, notice to the builder. All those done. Okay, you let me know which builder, what I can do, I'll tell you. We can do that, yeah. But you're clear about what to do. Apex federation is there, bylaw is also required, you have to do. That is what RERA chairman, someone has pointed out, you know, they have 10 towers, in that 7 is only completed. Then again the sanction is giving for another 2 without completing the third one.
Madam, can you just enlighten us on DOD, not conveying the DOD by the builder?
DOD is, sorry please, yeah.
And what is the implication if it is not done, but how to do it?
Okay, so DOD is the constitutional document of the association which is registered under the Karnataka Apartment Ownership Act. The procedure I'll tell you. If you want to register an association under the Karnataka Apartment Ownership Act, DOD, deed of declaration, has to be drafted. What are the contents in the deed of declaration? It discusses about the project. This project is 5 acres of project. This has these many units. And every apartment owner is entitled, or, his share is such and such, UDS. His super built up area is this. All these information will be there in the DOD. That is what I said, this DOD is a very important document. You will be getting only information about your property or apartment unit from your sale deed. You may not be getting a collective document, or you don't have a collective document which says that in this project A01 is such and such measurement, B01 is such and such, and B01 owner is entitled for 300 square feet, A01 person is. Why it is important? Because at the time of purchasing the property, you may not be having an option of verifying. Have you done any survey? Many projects I have seen that this UDS is not tallying with the available land. So I don't know what are there in this Alibaba's, whatever it is. But what I'm trying to say, UDS tallying is a very important thing. I forgot to speak about handover also. Handover is a very important thing.
But if it doesn't, the builder does not convey the DOD, what should be the...
Please don't use the word convey randomly. Convey means sale. You have to use this. You have to write in somewhere. Why you are selling your property again and again? You are the owner. If the builder is not executing, the word executing means builder is not,
writing or signing that document, creating that document, what you have to do, that is what your question is. You can approach the court, you can send a legal notice to the builder. You can approach me, I have some solutions for that, we can do that. But I have a suggestion to the government also. Now the Karnataka Apartment Ownership Act says that everyone has to give consent for this. And in an apartment where 50 units, 60 units, it's practically possible. But what about an apartment with 1,000 units or 2,000 units? Before sale, it is possible. The builder can do that. Builder can easily execute a deed of declaration. But after sale means he'll have to get the consent from each and every 2,000 unit owners. It is a practically difficult thing. This is the one people have to concentrate, not about KAOA and all those things. I really don't want to talk about that. That is this, government's job. My suggestions to everyone is that, this has to be amended. Yeah, you can see if all the owners are ready to come forward, if all the owners give consent, we can do that. I have done in an apartment where 1,980 units were there. It's a huge, work, but even then people have coordinated, they have called them, all of them have.
But DOD was supposed to be, whereas it's executed by the builder to enable him to sell the apartments. But whereas owners have to execute, one second, let me just finish. That DOA, that is deed of apartment, is something that the owners have to sign up for if you have to form an association. And now currently our association, which is an illegal board, has continued for almost 3 years without conducting any election, without conducting any meetings, is now insisting on a Form B and a membership. Now, as you said, DOD clearly says that we are all members, right? So why is a Form B required and a membership fee of 1,000?
That is a procedural thing. Every statute says that in procedures.
But in the KAOA Act, it is not said.
KAOA Act says that
only
there are... No, ma'am, let me complete. So in KAOA Act, there are two procedures. One is the deed of declaration, that is the parent document. The another one which is prescribed is an individual declaration.
Yeah,
deed of declaration is a collective declaration. Yeah. Individual declaration, it is very simple that I am ready to, execute this deed of declaration. It is a consent form kind of thing. Yeah, the legal language is that I am ready to bring my apartment unit under the Karnataka Apartment Ownership Act. That's the simple thing. But what is the problem in giving?
But that's a simple thing which was said in Form B. So why was Form B not initiated by the builder when he went to register each owner's sale deed? Correct?
If the deed of declaration is already executed and the election is conducted and your body is in place, there is no need of exercising it again. But in case if they are doing it, I am not saying that it is a wrong step also.
Listen, the election was deemed illegal by one of our competent, legally qualified owners, Mrs. 𝗵𝗿𝗀, who is also a member of the RERA, who said, from 2016 until 2024, she has filed a case with PHL, not paying maintenance. But now because of that case, she went to 𝗃𝗶𝗀𝗏𝗏 and got a waiver of all her MC for the last so many years. And that has affected all the owners who are paying. So how do we address this issue? Whereas this illegal board has supported her because her advocate is representing the association now to fight with the owners.
See, the answer to this is that if the deed of declaration is already been executed and if you have already conducted an election and everything is in place, there is no need of digging it again. That is one. In case if they are going to dig it again, there is absolutely nothing wrong in executing one more Form B declaration, confirming that I am also,
What is wrong? Probably some practical difficulty.
First and foremost, PHL didn't hand over a complete project. No.
Just get a broad guideline.
Yeah, broad guideline.
No, ma'am. What he is saying in the sense, we cannot club all these together. Association formation is one thing.
Yeah.
And the other things, what she has done, she has taken an advantage of the situation and very easily,
manipulate
everything.
Yes.
Many
But
people.
what about electricity now for us? We are suffering because PHL has not installed that substation, 66 kV substation. Earlier they said because of this lady's litigation, they could not proceed with it. And now we are still suffering. Today we had no power the whole day.
You send me what exactly the litigation. Let me go through that because it's a very fact-based issue.
And I have escalated all these issues to PAF since 1 year. Now just now I spoke to Mr. 𝗬𝗪𝗇 also. I said I have not had any response from your team. At least somebody should be able to guide us. How do we go ahead? I'm a non-resident. So when I come here, it does really affect me a lot. Because there is no proper authority to look into. There is no one we can escalate to.
I think I would like to respond to your issue back. Strictly speaking, we are not here to respond to public queries. We are here to respond to our members. Yes. If you are members of BAF is different, you said we have not responded. That's not the case because legally, I have not seen anything on my desk which is lying around connected to your issue as on date. If you're speaking with Satish on a personal ground, then please don't come here and say that we have not responded. I think I'll take it up very seriously. It's not a fair statement. We are all doing work pro bono and we expect that decorum to be maintained. I mean, you can't come here and make these kind of loud claims. They're not responding. We have not, sorry, under any obligation to respond.
One second now. Sorry. See, this, deed of declaration, are you clear? You're clear about, I'm asking everyone, you're clear about which association, one second, you're clear about which association you have to form, how to form an association you're clear about, what you should not do also, at least that you're clear about, don't convey your land, you're the landowners. We have to take this slogan, this apartment land belongs to apartment owners. It is in a small undivided portion. Right? Okay, if you are clear about that, I think the purpose of this Proprietas is served. And I'll definitely, sir. See, whatever queries ma'am is asking, deed of declaration is already been executed. According to me, 90% work is done. Right? If the builder can execute a deed of declaration in the initial stage itself, the law might have foreseen it actually. The law says that owner can bring the property. Before the sale, who is the owner? Builder is the owner. And the builder has brought the property under the act. So it is over. If there are multiple sales happened, during that time when he executed the deed of declaration, just imagine he executed the deed of declaration after 50 sales are over. 50 sale deeds are executed. Then he along with this 50 apartment owners are the owners of this property. So he will have to go and get Form B declaration from every 51. But the law says that before sale also he can bring the property. That is the best thing also. You have to insist each and every builder to register under the Karnataka Apartment Ownership Act before the sale itself. If we do that, if we insist for that, all this confusion will be over. Then on appropriate time, when you are ready to get the handover, you can constitute the committee, you can conduct the election, people will be there, you will be having a bylaw. If the bylaw drafted by the builder is not good, we can go ahead with amendment and make it a stronger one. All these can be done. Please don't, waste time on some consent letters. Form B importance is only that consent. Already it is done.
While you are all eager to ask questions, all of you had dinner? Yes. My humble sister has not had anything.
No problem. Please. I called them for their clarifications. I am ready. Ma'am, sorry, he is waiting for it.
It's a general question, madam. regarding the validity of the resolution passed in general body. And also the
One second, your association is under?
I am a member of this lab also.
No, I'm asking in your apartment, which association, under which act?
It is 1960 Act. One minute, I will come to that. See, one is that.
Sir, 1 second, after.
Let me complete it.
I understood.
Mine covers yours also. See, the validity of So, see, my question is for the validity of resolution passed in a general body. See, the fact is that, see, I belong to GR ends where 248 flats are there. So
340.
248. Okay. And whenever we call for a general body, only some 50 people, 30 to 50 people will turn up. So, whether the resolutions which we are taking there, whether it is valid or not.
Okay.
Yeah? Number one. No. Okay, sir, let me complete first.
Okay, I understood. I understood that question.
I am all the way over here to ask her. Not to you.
No, sir, please. Sir, please. Yeah.
So, this is the one point. The second is, see.
Can I answer to this and then?
You everybody, sir.
No, can I answer to this particular question? And then, see, he asked a question and he is also pointing out that quorum is not there. Okay, so what happened here? 248 units. Association is not valid, that I can say 1960. Forget about that. Just imagine it is a 1972 association, a valid association. They called for a general body meeting. They have sent communications to each and everyone. 248 received it. Only 15 has turned up. Whose fault is that? Is it committee's fault or your fault? You are not interested to go there. It is your responsibility to go and attend the meeting. If you are a responsible apartment owner. In your sale deed also there are a lot of clauses which mentions this. Right? You are not going there and you are saying that only 15 has attended the meeting. They passed resolution. How can you say that it is unilateral? Correct. Yeah. The legal answer is in the sense you didn't go and...
Act is bringing something to validate. Like I am a finance professional, whatever decisions, complaints like MCA, there is a written called how many resolutions a company passed, they have to upload in the portal, MCA portal every monthly or yearly. Like that, all associations should have a compliance mechanism, regulatory body.
Correct.
What are the resolutions they passed, how much quorum is there, and 2/3 majority is qualified.
I understood completely because almost all the things in apartment, every day apartment owners are coming and say, see, this problem, the legal answer in the sense, as I said, the principle of estoppel comes. What exactly it says? You had an option to go there. You didn't go. And how strong is your quorum is also one point. So normally in a quorum, you have to give an option if the apartment owners are not come, if your meeting is at 10, if the apartment owners are not come, 1 hour time, a gap, you can give it. And at 11 o'clock, you can start it. How strong is your bylaw? We have to cross-check it. And as you pointed out, IT Act is very clearly mentioned that online meetings can also be. So please create a mechanism where every apartment, we can as a group, we can think about it as a mechanism. You are the one who can guide me well because you are technologically advanced one. What we can do for making the participation more. As she pointed out, she's an NRI or someone, she can also sit there, she can vote it. So those kind of mechanisms we have to. Legally, this association is not valid. This 15-1, what you have done, now if we challenge it, it is difficult to stand before law.
My question is, at least for the future, regulatory mechanism should be there. At least if you make mandatory, the participation will be there. Otherwise, it won't be. I'm asking for a general. No.
Bylaw, yeah, that can be.
But bylaw specifically is stating that
in person. Is there any provision in your bylaws? No, what I'm saying, some bylaws are specifically mentioning in person. So you put it for general body meeting and pass a resolution. That was enough for you. Old means? 1972? See, general body meeting is enough for that. Because it is a legally accepted mechanism as per IT Act. No, I'm not saying that you can create a new set of bylaw. I'm talking about the mechanism of voting online. That can be done. But for changing the bylaw amendment, for the amendment, you need majority. General body meeting. You have to call a general body meeting and put this forward. What are the amendments you want to make? You have to... 3/4.
Let me specify, the DOD clearly says, if you want to edit the DOD, you need 75% of all owners present in person to agree to it.
That in person can be overcome through a resolution. That's what I said. That can be done. Then you just put it on online. You can do that.
Sir, I have just 2 words for you. I have to leave, ma'am. Just 2 words for you.
Thank you.
Because, ma'am, I have never seen a senior legal counsel. I have just 2 words for you and your team. Poli. It basically means I have never seen a legal counsel take time out to answer. You have a fantastic time. True. And we hope to continue to work.
Thank you so much. We will create a group, of course. Yeah. I got my energy.
On the same note, on behalf of Almond Tree Association, row houses and Willaments, and the entire gathering here, I really want to thank you, ma'am, and BAF, Mr. 𝗵𝗵𝗀, for the illustrative session. Thank you. We have many more such sessions to change the ecosystem. And for providing the platform, thank you for the bottom of my heart. And thank you for all the refreshments. It really takes efforts to organize such a mammoth task. So we are loads of gratitude. And
we will continue with these sessions, definitely. Thank you so much for attending also. Any questions didn't I answer?
I have. UDS is not there.
Why? When did they execute the sale deed? When? Are you sure that there is no DOD? Okay. But at least the DOD they have. Just see that advantage of executing the DOD. In the sale deed it is not there. In the DOD it is there.
Ma'am, I have...
Okay, fine, sir. You just show to me the document. I'll see.
Ma'am.
You come.
Ma'am, I have one more query here.
Ma'am, I am from Parasmani Regency apartment for which you have drafted the bylaw. Somehow it has not gained any traction and... I have seen the bylaws. I have in fact made some suggestions to the bylaws. So I just want to know the actual ground reality of not registration.
That is another thing. There is a cooperative group. They are threatening everywhere. So this loophole people have mentioned, no, everyone has to sign. Right? Your property is also sold. Without, they had filed many cases against the sub-registrars, criminal cases also, saying that I hadn't signed this, but even then DOD is registered. Now sub-registrars are worried about that. No government officials will be, they will not be ready to come. So that is what sub-register office, Next Legal is the only one who is doing the deed of declaration, that too with a lot of difficulties. Yours will also be done. Give us some time. This is the reality.
Got it. And deed of declaration is to be signed by both the owner and builder.
All the apartment. All the apartment.
And one more quick question, ma'am, on the parking.
Hello. Sukanya is also very good in...
I'm Sukanya.
Yeah, I'd like to finish that. See, my doubt is our apartment has a registered DOD under Apartments Act 1972.
Okay, builder has done that.
Has done it. So everyone who's basically doing the sale deed is getting it signed. That is sorted over there. But then I am the next association member. Prior what they have told, we have sent this particular document to RWA. RWA is not accepting it. They have clearly told we do not
Draft you are talking about.
Yeah, the DOD has gone, the election results have gone, everything has gone.
DOD is registered?
Registered. They have told we will not accept anything which is of 1972, only 1960 is what we will accept.
I can give you a case law. There is a direction to the society's registrar. Don't do this. A clear direction from the court.
They have sent it back.
Then you just coordinate with 𝗬𝗏𝗃. She will right away send it to you. Your number. Just in the group, I'll do one thing in the group. Certain legal points we will mention. I mean, some clips. So whatever I can do, I'll put it in the group. Be a part of the group. Right?
And certain other things that you have pointed out in terms of, as you said, the committee is responsible, like the issue that happened. Now, see, this is maybe common area. Some of them are, of course, putting their batteries, their whatever articles, wherever they feel like, in the common area. Even if the warnings are given, penalties are put. Are we legally allowed to move it out?
After giving a lot of
warnings
and everything, you remove it.
Committee is not responsible.
You can also give an explanation mentioning that these kinds of things are happening. We are responsible for that. But send proper communication to the owner in case if you want a legal notice also.
No, in EGM we have got this approval and put it on.
Car parking area is only for car parking.
Okay.
That you have to understand. If it is an individual house in your car parking area, whatever you want, you can put it. But when it is a community living, whatever is meant for or that area, there you can put only that.
My final query on legal.
Can the DOD be revised?
Amendment can be done. Before the OC. OC is not a... You can amend it. OC is not a condition for occupancy certificate is not required for. Yes.
No, I have one final
one more, sir. One more, only one.
No, but your sale deed is not executed, right?
Sale deed is executed.
Executed, but occupancy certificate you didn't receive. Sale deed is done without occupancy.
Ma'am,
then you are lucky.
Ma'am, we are.
Who has to leave?
Shabir, sir, he's actually waiting.
Ma'am, only one small question.
Shabir, thank you so much. His performance was also very wonderful, no? Yeah. Thank you so much. I'll keep in touch. Yeah. Tomorrow itself, I'll call you.
Ma'am, one small question, ma'am. Yeah, please.
Final query I have in terms of RERA. The validity, as you said, is for 5 years. RERA warranty is for a 5-year period, right?
Warranty for construction.
Yes. Now, builders are playing very smart in this way. Whatever you're building, structure, clubhouse, one part. Rest of the common area, landscaping, swimming pool, all that as the second part. They are handing over the building and stating from that day and the OC date onwards, RERA, whatever warranty starts. This, if they have completed, let's say, only 2 years back, they still state we have handed over. We have not accepted the handed over. We have formally written to them that we are not accepting your handover because of these issues. But they clearly state, as per RERA, we are through. We can't do anything.
No, handover you should not accept like, kind of a handing over a key. Handover is there's a lot of procedure connected. You have to cross-check all your sale deeds and a lot of things you have to cross-check. You pointed out the warranty issue. You capture everything in an agreement and then accept it.
See, as I said, I am the next. After 2 years, I have now taken over. Previous association, this has not happened. Now, what is the solution?
No, there is no point in saying previous and all. Now the solution. Already accepted?
They have also, no one has taken the handover. It's only a mail from the developer.
And then you demand for handover. You can just, is there any documentation which is mentioned that, project is handed over to you? Signed by you?
No, none of them.
I'll check it and then after that I'll give a solution.
Ma'am.
So, some people are waiting for that. So I'm so, give me a second.